Call to order. Aloha mai kako. Good morning, everyone. This is the April 3rd, 2024 Land Use Commission meeting. This is an in-person meeting which is being held at the Homer A. Maxey Center Conference Room, which is Foreign Trade Zone number 9 here at 521 Ala Moana Boulevard, Honolulu. And this meeting is open to the public. Court reporting transcriptions are being done from this meeting via a Zoom recording. So everything is being recorded on Zoom. For all meeting participants, and I will be repeating this message throughout the morning and afternoon, I'd like to stress the importance of you speaking slowly, clearly, and directly into your microphone. Before speaking, please state your name and identify yourself for the record each time you prepare to speak. So although this is an in-person meeting, please be aware that all meeting participants are being recorded on the digital record of this Zoom meeting, and it will be posted on YouTube, and it will be used for court reporting purposes. So your continued participation is your implied consent to be part of the public record of this event. If you do not wish to be part of the public record, you should exit the meeting now. And it looks like everybody's staying here, so that's great. I will also share with all participants that we'll be taking breaks from time to time, including a longer break for lunch. So approximately every hour, we'll take a 5 to 10 minute break. And then at around noontime, we'll take a lunch break. My name is Dan Giovanni, and I have the pleasure to serve as the LUC chair. And we currently have 9 seated commissioners, 8 of which are here today. Along with me are Commissioners Lee Ohigashi from Maui, Commissioner Gary Okuda, Commissioner George Atta, Commissioner Mel Kahele, Commissioner Brian Lee from Oʻahu, Commissioner Michael Yamane from Kauai, Commissioner Nancy Carr Smith from the island of Hawaii.
One, two, three.
1, 2, 3, and I'm good again. I believe the last thing I said on the record when I had the microphone was that with us today is Commissioner Nancy Carr Smith from the island of Hawaii. Commissioner Kuike Kamakea Ohelo is excused from today's meeting. Also in attendance is the LUC Executive Officer Daniel Orendanker, LUC Chief Planner Scott Derrickson, LUC Staff Planner Martina Segura. Not me. LUC Chief Clerk Ariana Kwan in the music, and LUC Attorney General to my right, Mr. Dan Morris. Our first order of business is the adoption of the March 7, 2024 minutes. Ms. Kwan, has there been any written testimony submitted on the minutes for March 7th, 2024?
No, Mr. Chair.
Are there any members of the public who have signed up to testify on the adoption of the minutes of March 7, 2024?
No testimony regarding the minutes.
Thank you. Commissioners, are there any corrections or comments on the minutes? If not, is there a motion to adopt the minutes for March 7, 2024?
Mr. Chair, move to adopt the minutes.
Commissioner Ohigashi moves to adopt the minutes. Do I have a second?
Mr. Chair, second.
Who is that? Commissioner Yamane moves to second. So I will recuse myself from a voice vote since I was not in attendance at that meeting, but all in favor of adoption of minutes, please say aye.
Aye.
Is anyone opposed? The minutes are adopted. Thank you. The next agenda item is the tentative meeting schedule, and I'll call on Mr. Orendanker to present.
Thank you, Mr. Chair. Tomorrow, we are here again at the same location for the Halekua development motion. On April 17th and 18th, we have a tentative meeting scheduled, but nothing on the agenda so far. But please wait for word from our chief clerk before you release those dates. On May 8th.
Please speak directly.
On May eighth, we will be on Maui for the AMFAC HHFDC status report. And on the 9th, we tentatively have scheduled a Zoom meeting to discuss the OPSD soil study. On May 21st, we will be once again here for the Waimanalo Gulch matter, the 21st and the 22nd. That is tentative. We are awaiting the decision of the county council today for a firm date. On June 5th, we will also have tentatively scheduled the Oʻahu, the Waimanalo Gulch matter. On June 6th, we tentatively have scheduled virtual Zoom meeting for proposed rule amendments. And on the 19th and 20th of June, we have meetings on Maui for the Central Maui landfill status report and the A11792 DHHC status report. In July, on the 10th and the 11th, we have tentatively scheduled commissioner training. That will be on Oʻahu, but location is undetermined right now. On July 24th, we will be on Maui for the Emmanuel Lutheran status report. August is currently open. And then in September, 11th, 12th, and 13th is the HCPO on the Big Island. And that takes us through the schedule to October.
Thank you. Commissioners, any questions or comments on the schedule? Hearing none. Our fourth order of business is a status report and progress report on A92-683 Halekua Development Corporation of Oʻahu. The status report is being presented by petitioners in the Halekua docket. At this point, I'd like all the parties to identify themselves for the record, and I'll start with the petitioners. Mr. Tabata, you want to go first? And then we'll go down the line. And please introduce who's with you.
Testing. Good morning, Chair, members of the Commission, Curtis Tabata, Benjamin Matsukawa for Haseko. Also present to my left is Haseko Vice President Peter Kwan.
Morning, Mr. Chair and Commission members. Stephen Mall on behalf of Robinson Kunia Land LLC.
Is anyone with you?
No one is here with me.
Thank you.
Good morning, Chair and Commissioners. This is Jennifer Lim. I'm here representing Ho'ohana Solar One LLC, the lessee of the Robinson Kunia land parcel. And to my left is Mr. Larry Green, and he is the Senior Vice President Project Development for the Ho'ohana Solar Company.
Thank you.
Good morning, Chairman, Commissioners. Terry Lee, counsel for RK2 Partners. Also in attendance as co-counsel is Derek Kobayashi. And in attendance in the audience is David Tanoy from RM Towel, who's our consultant, and Eric Elkine, who's also co-counsel, and Mike Wright, who's a consultant and principal of RK2 Partners. Thank you.
Is that everyone for the petitioners? Let me let the chair thank everybody for showing up today. It's nice to see in a complicated matter where there's a lot of different interests that they all show up. So thank you for that. So let me turn now to the City and County of Honolulu. Introduce yourself and your team.
Aloha, Chair and Commissioners. My name is Pono Arias, Deputy Corporation Counsel on behalf of the city. With me, I have Dina Wong from the Department of Planning and Permitting and Patricia Sendao, Deputy Corporation Counsel.
Thank you very much. From OPSD.
Good morning. Allison Cato, Deputy Attorney General for the Office of Planning and Sustainable Development. Also here is Katia Balaciano and Brandon Su, who is actually new. He just started a couple of months ago. He'll likely be working on LUC matters going forward. And so he's just here for introduction purposes. That's him right there.
Welcome, Brandon.
Good morning, Kelsey Nagata, Deputy Attorney General for the Department of Agriculture. With me at the table is Brian Call, and behind in the audience is Janice Fujimoto.
Thank you very much. I'd like now to describe and explain our procedures for going forward. First, I will ask if there are any disclosures from the commissioners, and then I will update the record. Then I will recognize the written public testimony that has been submitted in this matter, identifying the person or organizations who have submitted the testimony. Next, I will call for members of the public who wish to testify on the status and progress report. Each member of the public will have 2 minutes to provide their testimony and should stand by after their testimony to respond to any questions from the parties or the commissioners. When all questions have been completed, the chair will excuse the witness and call the next witness to enter the box. After completion of the public testimony of the proceedings, the chair would like the petitioners to provide their status report, beginning with Haseko, then Ho'ohana, and so on. The chair will then call on the parties, the Department of Agriculture, OPSD, and the county's planning department for comments regarding the status report. The petitioners will then be allowed to respond to comments made by the county, by the Department of Agriculture, and OPSD. The commissioners will ask questions of the parties at the conclusion of each of their presentations. At the conclusion of the parties' testimony and commissioners' questions, the public will again be granted the opportunity to provide public testimony in the same manner as set forth previously. Once testimony concludes, the commission will enter into deliberations regarding the status report and to decide if any action is necessary. Again, I want to remind everyone of 2 things. When you are speaking, please introduce yourself and name your affiliation and speak directly and clearly into the microphone for recording purposes. And I will be calling short breaks on a nominal hourly basis and then also for a lunch break. Does anyone that's been introduced have any questions on the procedures for today? Do any commissioners have any disclosures to make at this time? Seeing none, we'll proceed. Please be informed that relevant records and documents pertaining to this matter can be accessed for review on the LUC website. That's the LUC website is https://luc.hawaii.gov/A92-683. Public testimony. For members of the public, again, please be reminded that the commission will not be considering the merits of this petition. Rather, the commission is interested in learning about the current state of activities related to the docket, including compliance with conditions and will consider whether action is necessary. I will now recognize written public testimony submitted in this matter, identifying the person or organizations submitting the testimony. Ms. Kwan, has there been any written testimony received?
No, Mr. Chair.
Thank you. Now I will call on any members of the public to provide testimony on this agenda item. Ms. Kwan, are there any members of the public present who wish to testify?
We have 2 members who would like to testify. First, we have Frankie Rife.
Mr. Wright, will you take your place? I will like you to give us your name and address, and then I'll swear you in before you testify.
Good morning, everyone. Aloha. My name is Frankie Rife. I live at 94-847 Leia Street.
Mr. Wright, do you swear that the testimony you're about to give today will be the truth?
Yes, sir.
Okay, please proceed. You have 2 minutes.
Thank you. Once again, good morning, everyone. Aloha. My name is Frankie Rife, and I have lived in Royal Kunia Site 299 for 19 years. It is a wonderful neighborhood where I've raised 5 children and plan on staying for the rest of my life. I am in favor of the long-delayed Royal Kunia 2 project. After passing through many developers, I couldn't be any happier for the community that it was Halekua that purchased the land, the intent to develop much-needed single, 2-family, multifamily units, and mixed affordable units and middle income units. With Halekua's purchase of Royal Kunia 2, the long-awaited Royal Kunia Elementary School will come to fruition, taking enormous pressure off Kaleopu Elementary School for many years of overcrowding. I've had the privilege to be a subcontractor to Halekua Hawaii for the last 25 years, working in the Everglades on their projects, Ocean Point and Ho'akale. They have built an astonishing, beautiful community that is thriving and maturing into one of the best coveted neighborhoods in West Oʻahu. Halekua takes pride in their communities, and I am very glad that Royal Kunia 2 has ended up in capable hands. Thank you very much.
Thank you, Mr. Rife, for your testimony. Please stand by for questions. Any of the petitioners have a question for Mr. Rife?
Curtis Tabata, no questions.
Thank you, Mr. Next.
Stephen Mao, no questions.
Jennifer Lim, no questions. Thanks.
Terry Lee, no questions.
Thank you. County, any questions?
Pono Arias, no questions.
Thank you. OPSD, any questions?
Allison Kato, no questions.
Thank you. Department of Agriculture, any questions?
Kelsey Nagata, no questions.
Thank you. Commissioners, any questions or comments? Thank you, Mr. Rife. You're excused.
Thank you.
Next, I have Chris Delaney.
Mr. Delaney, would you please state your name and address, and then I'll swear you in?
Sure. Chris Delaney on behalf of Pacific Resource Partnership, 1100 Alakea Street, Honolulu, Hawaii.
Do you swear your testimony today will be the truth?
I do.
Please proceed. You have 2 minutes.
Pacific Resource Partnership is a nonprofit organization representing the Hawaii Regional Council of Carpenters and approximately 250 contractors in the state of Hawaii. We are in strong support of the Royal Kunia Phase 2 project. As you know, in 2019, the Hawaii Housing Planning Study found that the state needs more than 50,000 homes to be built between 2020 and 2025, including affordable housing at the 120% AMI income rate. This project will help to provide more housing options for Hawaii residents at various price points. The project will have a total of 1,850 homes. At least 30% of these homes will be set aside for affordable housing. The first phase of the parcel, Parcel D, consists of 324 units, of which 68 of these units will be affordable homes. We find that this project is important to complete, bringing a lot of benefits to Hawaii residents, as well as it will create construction jobs for Hawaii's residents, paying them a living wage with benefits. These are the types of jobs residents need, and give them opportunity to afford Hawaii's high cost of living, keep residents off of welfare and other government assistance programs, and stimulates our economy and provides economic stability for workers and their families. Thank you for this opportunity to testify.
Thank you very much. Please stand by. Mr. Tabata, any questions?
Curtis Tabata, no questions.
Next.
Stephen Mao, no questions.
Jennifer Lim, no questions.
Terry Lee, no questions.
Thank you. County?
Pono Arias, no questions.
OPSD,
Allison Kato, no questions.
Department of Ag.
Kelsey Nagata, no questions.
Thank you all. Commissioners, any questions? Commissioner Okuda.
Thank you very much for coming to testify here today.
Thank you.
Your organization, PRP, you basically have certain expertise, you believe in the area of development, housing, and things like that. Is that a fair statement?
It's partially true. We believe in responsible construction. We believe in creating more affordable housing. We also believe in creating more jobs, advocating for more jobs that pay a living wage and benefits so our residents, our local residents can afford the high cost of living in Hawaii.
Yeah. This project dates back, as far as I can tell, to the original findings of fact were filed December 9, 1993. You agree with that statement?
I don't have that information in front of me right now.
Yeah, but this project has been pending, and forgive me because I haven't had math since 10th grade of high school, but I think that's like 30 years.
Okay.
Yeah. You know, and I'm asking you this because you come from an organization that I believe has clear expertise and experience in this area. The testimony you gave, which I think is very strong testimony, when I reviewed the prior findings, that's basically what the commission 30 plus years ago was being told. In other words, we have a really good developer here, Herbert Harita. He has a track record of building projects. These are projects where local people, live and raise families. This project is going to create jobs. This project is going to, be a positive thing for the community. And then here we are 30 plus years later, and, we're kind of hearing the same thing. Based on your experience and your organization's experience, what can the Land Use Commission do to make sure that when housing for local people are being promised and when jobs for local people are being promised, it's actually going to take place, and we're not going to be here another 30 years later hearing that, oh, wow, we have the Gary Okuda Development Company, and, this guy, Gary Okuda Development Company, they're really going to do the job. I mean, what can we on the commission do to make sure that promises are kept?
Well, that's up to the commission, really. It's not my position to kind of dictate what the commission should do. I think they should listen to the petitioners and, yeah.
Do you think this is a problem for the community where promises are made and time shows that these promises aren't kept?
Well, I'm just here supporting the project, and they're here today to kind of explain their position, and it's a great project, and I think we need to build more housing, and this is what this project does. So I see this project as a benefit. That's all I can speak to right now.
Do you think it might make sense that in the appropriate case, I'm not saying this is the appropriate case, but in an appropriate case, that government agencies add as a requirement the posting of a completion bond or a bond, so that if promises aren't kept, the bonding company will step in and complete the project as promised to the community?
I can't comment on that.
Oh, okay.
Yeah.
Okay, I thought, based on your background, you might be able to, but thank you very much
Yeah.
for coming and taking your
Okay.
time. Appreciate it.
Thank you.
Thank you. Commissioners, any other questions? Thank you, sir. Any other public testimony sign up? Okay, now we'll proceed to the status report. We're going to go in the following order: Haseko, Oʻahu, RK2 Partners, and RKS. So we'll start with Haseko. So Haseko, will you please provide your status report?
Thank you, Chair. Curtis Tabata for Haseko. We're going to start with our first witness, Peter Kwan, who's sitting right here to my left.
Mr. Kwan, I need to swear you in. Will you please state your name and address and affiliation?
Peter Kwan, address 91-1001 Kaimalie Street, Suite 205, Evo Beach, Hawaii, 96706. I am the Vice President of Site Development for Haseko.
Do you swear your testimony today will be the truth?
I do.
Oh, please proceed. Please proceed.
Peter, let's go over your background real quick. What is your educational background?
I have a Bachelor of Science degree in Mechanical Engineering from the University of Washington.
And do you hold any professional licenses?
I do. I have a contractor's license, classifications A, B, and C, and I am the RME for all of Haseko's construction entities.
And could you briefly go over your employment history prior to Haseko?
Sure. I started my career working the first 25 years from 1988 to 2013 for Hawaiian Dredging Construction Company in their heavy division, working on a number of projects across the state on all of the major islands. In 2013, I moved to Delta Construction, where I started off as Director of Operations and Business Development, eventually becoming Senior Vice President of Operations. I left Delta in 2017 to join Haseko. And I currently work in the Site Development Department, which basically we cover all of the civil construction on all of our properties.
Thanks, Peter. Let's go over Haseko's background real quick. How long has Haseko been a developer in Hawaii?
We have been a developer in Hawaii since 1973.
And how many homes has Haseko built and sold in Hawaii?
At last count, it's approximately 7,022 units.
And how many square feet of commercial property has Haseko developed in Hawaii?
We have developed over 564,000 square feet of commercial space.
How many employees does Haseko have in Hawaii?
We have 43 employees.
Thanks. Let's turn to Royal Kunia 2. Now, Haseko acquired approximately 211 acres at Royal Kunia 2 in 2020. Is that correct?
That is correct.
Can you please describe for us how Haseko came to that decision to acquire that land at Royal Kunia 2?
At our current project in Ocean Point and Huakale, we have about 800 to 900 more residential units to go, as well as some other areas of our property. We looked at the Royal Kunia 2 project as a project that we could move on to and continue to do what we do best, which is to build residential housing for Hawaii.
Thank you, Peter. Chair, is it okay if we share screen on Zoom to show one of our exhibits?
Yeah, yes, please do.
Thank you. This is Exhibit 6 from our motion, which is scheduled for tomorrow, but we would like to show it today. Peter, could you share screen for us, please? And for the record, this is Exhibit 6 to our motion, scheduled for tomorrow. This is it's called the Royal Kunia 2 Master Plan Phasing, showing our master plan. Thank you, Peter. Peter, could you please describe for us how Haseko came up with this master plan?
In our initial planning, we designated 5 different parcels of residential homes, what was going to be a mixture of single family, multifamily, townhouse type units. The first phase that we are going to develop is what we call our parcel D, which is in yellow in the lower right-hand corner of the map. The reason it was selected to be the first area is because of its proximity to the existing Royal Kunia 1 subdivision and existing streets and utility connections on Hononui Street and Onowiki Street. And also the surrounding infrastructure around parcel D, which hopefully you can read the map, includes Road Y Phase 1, which is the extension of Hononui Street to the north, Road X, which is the east-west section just above parcel D, and On the left of parcel D is what we call Road 3, which is a north-south section that will also provide the first connection to the industrial parcel to our north. In addition to this, after this first parcel here, which will include 324 units, 260 single family, 64 multifamily, there's a second component to it just above called Phase 1B. Those are 36 units of multifamily. These two phases combined, 1A and 1B, comprise our first 360 units, which will comprise our first phase of residential development, plus the roadways that support them. The other phases, we have to have other parcels. We have parcels A, B, C, and E. But what we did was, as you can see, those are actually running north-south. But what we did was we decided to combine sections of these various phases so that we can offer a variety of product in each of our phases as we build them and sell the homes. Phase 2 is the green section, just above and to the right of parcel D. That includes a mixture of our parcels A, B, and C from left to right. And also the first section of what we call Road Z in green, which will ultimately go up to the northern boundary of our property and provide a future roadway connection to Robinson Kunia Lands residential developments in the future. The third phase is in orange, which is the next section. North of that, again, a mixture of parcels A, B, and C from left to right. From there, the plan was to move out towards Kunia Road into the blue section, which we call our parcel E, and would also include the development of the park, which is under note 16. That is about a 5.5 acre park that would be located immediately north of the school lot that's currently owned by RKES. The final phase is in pink up in the upper right-hand corner of the development, phase 5, which will be the final units. Again, this will be a mixture across parcels B and C at the top, and it'll complete our roadway connection and utility provisions to Robinson's lands for the future.
Thank you, Peter. Here, let's talk about our MOU with the Department of Agriculture. Chair, we would like to now share screen Exhibit 9 from our motion, which is the Fifth Amendment to Amendment of Restatement of Memorandum of Understanding dated January 10th, 2024 between Haseko and the Department of Agriculture, who I shall refer to as DOA. Is that okay, Chair?
Please proceed.
Thank you. Yes, please bring up, no,
Exhibit 9.
Exhibit 9, yes. Actually, Peter, could we just describe for us, we'll actually need to share a screen in a different exhibit later, Exhibit 1. But could you describe for us,
Mr. Tabata, so we're not going to put up Exhibit 9 at this time?
correct, I'm just referring to it, that's an exhibit that we're talking about right now.
Very well.
So, Peter, could you describe for us your understanding or the purpose of the MOU?
Peter Kwan. Our MOU with the Department of Agriculture covers our obligations to provide irrigation infrastructure, temporary infrastructure, and interim infrastructure and permanent infrastructure for the Department of Agriculture's property. The irrigation infrastructure includes a non-potable water line that is coming down from the 665-foot reservoir. I think it's also called Reservoir 225, if I'm not mistaken, which is further north, just south of the Hawaii Country Club golf course. A 12-inch non-potable irrigation line has been installed. It will include a mechanical pump with electrical power that is still part of the project to be installed that will carry.
Excuse me, Peter. Chair, actually, we would like to share screen Exhibit 1 from our motion, which is our petition area map. And that'll help show where these infrastructure are located on the project.
Very well. So we'll put up exhibit 1 on the screen, and Mr. Kwan, you'll be speaking. Since we're just putting it up now, would you identify where the items 1 and 2 are located?
Thank you. Peter, could you again describe for us the location of the irrigation infrastructure?
Peter Kwan. On the left side of the map, we have a call out for the irrigation lines originating at Reservoir 225. It is represented by the blue line that is running down along the east side of Kinea Road from north to south, and it runs down to the northwest corner of the Department of Agriculture's agricultural park. A 12-inch line is being run to that point from which the Department of Agriculture will be able to draw non-potable water for irrigation purposes for their property.
Let me just, is Ag Park shown on this?
Yes, excuse me. The first property on the upper left-hand corner in blue is the DOA Agricultural Park, TMK 9-4-002 080.
Thank you for that clarification.
And Peter, looking at the same map, if you could scroll down just a little bit and describe the location of the Haseko properties.
Peter Kwan. Haseko's property is in orange on this map. It runs all the way from Kunea Road to on the west side up to it's bordered by RK2 Partners property in yellow, who is on our north, and we run all the way to the east in the orange, and we abut Robinson Kunea lands parcel 52, which is in green, wrapped around the upper boundary of our property.
Thank you. And in the MOU, there is a permanent infrastructure described, correct?
That's correct.
And could you describe for the commission the location of the permanent infrastructure line?
Mr. Tabata, Mr. Kwan, just to clarify, originally, Mr. Kwan, you said there were 3 parts to the MOU, and you described 2 of them, but not the third. Is this the third coming forward now, or?
This is the second.
Second was the pump.
No, the first was the irrigation infrastructure, and that's comprised of the 12-inch pipe, the water line, and the pump.
That's number 1.
That's number 1. And so the pump is located next to the reservoir. I believe it's 225. And that's the source. And then the pump then sends the water down the pipe to the ag park. So the irrigation infrastructure is number 1. Number 2 is the permanent infrastructure, which is required to be built by September of 2028, September 30th. And Mr. Kwan can show the commission the location of the permanent infrastructure. And Peter, it might be more helpful to show exhibit 6 again, because that shows the location of road Y. Thank you, Peter. If you could use your cursor and show the location of road Y, which is the location of the permanent infrastructure line.
Hopefully folks can see it on the screen. I have my pointer currently at the top of the existing Anunui Street at the lower right-hand corner of the yellow. Trying to wiggle it here so we can see. The permanent infrastructure for the Department of Agriculture that, as Curtis mentioned, is due on September 30th of 2028 will go up our what we call our road Y, which is basically the extension of Anunui Street to the north. It'll run through our major intersection in our residential development here and continue on north up the yellow path that you see. All the way to this point here where we have a side access road that will go up to what's the Robinson property across a short easement to the boundary of the Department of Agriculture's property. This roadway will be a paved access. It will be a public roadway, and it will include potable water, gravity sewer, electrical lines, and communication lines for the Department of Agriculture.
Thank you, Peter. Chair, were you able to see where Road Y is located?
Yes, I was. Commissioners, anybody else want further clarification?
I could,
My only question, the permanent infrastructure is underground?
Yes, Commissioner. Yes, Chair, that's correct.
Thanks. Please proceed.
Yeah, I just wanted to know.
Commissioner Higashi.
Yeah, I just wanted to know if, using exhibit 1 and 6, if you can give me an idea where exhibit 6 is located within exhibit 1.
okay, thank you.
It's on that orange section, I know, but I'm just trying to.
So let's put up exhibit 1, and when it comes up, please describe what portion of that is represented by exhibit
Just trying
6.
Get the idea where that road Y is going to go to.
Understood. Thank
Is it
you.
the pink, or is it the?
Thank you, Commissioner. That's an excellent point. Let me go up there and just point at it. Peter, if you could bring up exhibit 1 and let me know if I'm pointing at the correct area.
The road goes up to the green property. Robinson Cuneo Land LLC. Is that what you're saying?
Mr. Vice Chair, it goes up to the right-hand corner in that angled section of the Department of Agriculture's property in the blue, which is the blue section. That is road wide, more or less, yes. And it goes up along and it cuts over and connects to the Department of Agriculture's property along that angled corner there.
We're good. So when Mr. Tabata gets back to his seat, you may resume.
Thank you, Peter. The third category of infrastructure is the temporary infrastructure. So as we were negotiating with DOA, we were informed that 2028 was too late for what they needed. And what they needed first was functional electrical power and potable water for agriculture. I believe washing tools, but for agriculture. And they needed that by 2025. So we have until the end of 2025 to provide those two temporary infrastructure. So we're going to have to build a new line. Road Y is not going to be built by 2025. So there's going to be a totally separate line for electricity and potable water. And I believe the location of that line is not yet been determined. We need to work with Hawaiian Electric, Board of Water Supply. We're working on it. Peter, is there anything else to add about the temporary infrastructure?
No, that's correct.
That'd be above ground.
The temporary infrastructure will most likely be above ground.
Thank you.
I believe that's it. Mr. Kwan is available for questions.
Thank you. Commissioners, any questions for Mr. Tabata or Mr. Kwan?
Mr. Chair.
Commissioner Yamane?
Thank you. Just a question on the temporary infrastructure. What, do you know the nearest location of permanent electrical infrastructure and water to the DOA site? Like,
Peter Kwan. Yes. We currently have options for power, and again, our electrical consultants are working directly with HECO on this matter. I guess that we have a couple of options. There is existing power stubbed out at Hononui Street. It's also available along Anoiki Street, which runs along the southern boundary of our property. But they have also mentioned that they may want to bring it in directly from Kunia Road. We're not sure what that would entail on how to get across Kunia Road. But I guess we'll be working on those details if that becomes a viable option. For water, there is, at least for now, for a temporary feed, there is a temporary meter on an existing fire hydrant at the end of the existing Hononui Street that can be utilized and connected to take water up to the, hopefully the nearest point on the Department of Agricultural's property to provide the potable water.
thank you. No more questions, Mr. Chair. Thank you.
Thank you. Commissioner Okugashi?
I'm not sure if this is for the DOA or yourself. My question is really, why 2025? And the second part is, what if you don't meet the 2025 deadline? What things will happen, or what consequences will happen? I'm not talking about between you and DOA, but what are the consequences if you don't meet the 2025 deadline? Should it be to the DOA?
Well, I'd like to hear it from both parties. So when we get to DOA, why don't you ask that question again? I'll remember for you if you figure.
2025 is, again, that's DOA determined that. So they can speak to, why 2025. As far as what happens if we don't meet the deadline, we have an agreement. So I don't want to lay out their complaint at circuit court against us. But we have an agreement. I believe it's enforceable. And there's, and there's bonding too. But I believe the bonding is tied to the permanent infrastructure. But it's I believe it's an enforceable agreement. So, I'll leave it at that.
So I think you kind of spoke to the potential consequences in a legal sense or financial sense, but when we hear from DOA, I'd like to know, what if they don't get the water and the electricity? What happens at the ag park? So just would like to hear that. So that's kind of a upfront question to DOA when it's their turn. Okay. So, my question following on Commissioner Yamane, do you have clarification on the quantity of power and water that would be needed on a temporary basis, or is that still under negotiation as well?
No, they did provide that for us.
So you have.
Peter, can you speak to that?
Yes, the Department of Agriculture has provided the loads that they need to service.
Great. Commissioners, anything further? Commissioner Okuda?
Thank you very much, Mr. Chair. And Mr. Tabata or Mr. Matsubara, if you believe you're better suited to answer these questions, you can do so also. Just to frame my question, the question I'm going to be asking now goes to the issue of whether or not there's been substantial commencement of the use of the property as that term has been defined in the Bridge Ainalea case. I'm not saying that there's going to be an attempt to revert the land or the property back to prior boundary designations, but I'm just trying to see where we are. The amended findings of fact and conclusions of the law and the decision and order which was filed October 1, 1996, at paragraph 25, laid out what the intended use ultimately of the property is. And just so that we were clear about the property, the Haseko owns only now a portion of the overall property or parcel which was subject to this boundary amendment and docket, correct?
Yes,
Okay. And the decision and orders which spell out or set forth certain conditions and the findings of fact and conclusions of law which document the representations that were made to the Land Use Commission. Do you agree that the decision and order, the findings of fact, the conclusions of law are encumbrances on title?
it runs with the land. Yes,
Okay. And that term runs with the land that we lawyers use means that whomever goes and obtains an interest in the property, unless those encumbrances or items are released, are subject to and have to follow those encumbrances, correct?
that's correct.
And we don't have to get into the details of what the legal effect is of encumbrances that run with the land, but one of the cases that lay out these rules, which again, we don't have to go over, is the Waikiki Malia Hotel Incorporated versus Kinkai, Kinkai Properties case. That's the 1993 Hawaii Supreme Court case. I think it's found at 75 Hawaii Reports 370. Does that case ring a bell to your mind?
That is not one of the cases I briefed for these hearings.
Oh, okay, okay. Well, anyway, going to, what, for example, the amended findings of fact stated, there was a list at paragraph 25 of what the land use plan consisted of, or the petitioner's revised land use plan was. And it provided for the construction of 1,250 single-family residential units occupying 290.8 acres. How many of those single-family units have been built as of today?
The residential units, none of them have been built yet.
Okay. And then at paragraph 25, there was a statement that there would be 750 low-density apartment units built covering 70.3 acres. How many of those low-density apartment units have been built as of today?
None, but I think I can cut to the chase and answer your question about substantial commencement.
Yeah, just bear with me because I'm only going to ask 3 more questions. I just want to confirm that the acreage designated for light industrial use, which was 123.7 acres, none of that's been used for light industrial at this point in time. Is that correct?
I cannot speak for the industrial property, but I don't think so.
Okay, and we don't have 8 acres of school or 11.1 acres for a public park, correct?
That's my understanding. What we do have, Commissioner, is all the effort and money that we've spent, Haseko spent after they acquired the land in 2020. And I know there's maybe a disagreement about what constitutes substantial commencement. Some people may believe it only relates to vertical construction. Okay, but I don't agree with that. I believe it includes soft costs like engineering and planning and design and permitting, which if you add them all up for a project of this magnitude, is significant. We're talking tens of millions of dollars since 2020, after we bought the property. So if you're looking at the Bridge on Alea case and the wording in that case about what is substantial commencement, and they talk about the legislative history about what the purpose of 2054G was, to allow for the downzoning of land. It was basically to prevent land speculation. Okay, they don't want land banking, and that's not what we're doing here. That's why we went over Haseko and how many employees they have, how long they've been here. They're developers. They're not land bankers. Okay, they don't speculate. They have they have too much overhead to just be sitting on land. They need to develop, build, and sell, and that's what they're doing. So to answer your question, yes, we have substantially commenced, and it's because we've spent a lot of money since we've bought the land, and we're proceeding. We're not speculating, and that's our response.
Do you believe that whether or not substantial commencement, as that term is used in the Bridge Ainale case, has taken place or not taken place, is a factual determination to be made by the Land Use Commission as the designated government agency? In other words, it's a finding of fact, or it'll be a factual finding, whether it took place or did not take place.
I think it may be a conclusion of law or a mixed question of fact and law. It's a statutory term, and it's based upon facts relating to the developer's efforts to actually build a project. So what would clearly be facts would be the amount of money that they spent designing, engineering, constructing, permitting, everything expended, including time and effort to develop the project. So I'm not sure. I'm thinking it's a question of law, conclusion of law.
Yeah, do you know any case that says that determination, which seems to be a factual determination, is in fact a conclusion of law, not a finding of fact, which the Land Use Commission, using its discretion, would make?
The reason why I think it's a conclusion of law is that, just as I had to explain that there's differences of opinions of what may constitute substantial commencement. Okay, so and that requires a person like you and me to go read the Bridge Ainale case, dissect it, try to understand it, and make sense of it, and that requires basically lawyer work. Okay, and that's why I think it's legal and a legal question. So if you ask the witness, did you substantially commence? I'm afraid I'll have to object that it calls for a legal conclusion, because how would he know? Because I know he hasn't gone through the Bridge Ainale case and dissected it and given it a legal analysis. So I mean, I don't know if Bridge actually said it's a conclusion of law or a legal question, but I believe it may be a legal question.
Okay, let me shift gears a bit. And my next question is not intended to be a criticism of any agency or anything like that. And let me state for the record that I think our dear friend Don Takeuchi Apuna, who appeared for many, many years as Deputy Attorney General representing the Office of Planning, has really tried to do an outstanding job down at DPP. So my next question is not intended to be a criticism of anyone at DPP or anything like that. But if you could have, just as a suggestion, and this is again, not pointing fingers or anything, if there are 1, 2, or 3 things which you could have the DPP do, and again, not saying anybody's going to ignore the law, cut corners, or do anything illegal. Okay, that's not the purpose of this question. But if there are 1, 2, or 3 suggestions you would have to maybe ease the burden if Haseko is going forward with this project, what would be the suggestions that you would make to maybe kind of assist the compliance with law, for example, with DPP?
Be honest, I don't know. I mean, I have full confidence in Dawn. I've known her for years. I think she's doing a great job over there. She's got a difficult job at DPP. So I trust her that she's gonna run her department as efficiently as possible.
Okay, and my final question, and this is maybe, and if you don't want to comment because we have your hearing tomorrow. But if you had any suggestions, again, not to subvert the law or do any backdoor deals or anything like that, on how the Land Use Commission could be more responsive to people like Haseko. You have any 1, 2, or 3 suggestions?
Again, I mean, I think the commissioners, everybody here, I think, you know, with all of our experience, we understand how difficult it is to do one of these projects. I mean, this project has been, you know, it's taken a while to get to this point. Everybody's doing the best, I think. I'm thoroughly impressed with the people in this room and how they do their work. So, I don't have any specific recommendations, no.
Okay, and just a technical point so that maybe we don't have to re-ask the same questions tomorrow. Do you believe that what's stated and what's testified in this room here today, not only from Haseko, but from everyone else, forms part of the record which can be considered with any further proceedings, including what takes place tomorrow?
I believe so, yes.
Okay, thank you, Mr. Chair. I have no further questions.
Thank you, Commissioner Okuda. Commissioner Ohigashi.
Mr. Tabata, this project is a very difficult project to follow, right? The problem is that we have one boundary amendment, findings of fact, conclusions of law, that deals with, what is it, 6 different areas under different ownerships of, was it 5 or 6 different areas? Anyway, different ownership. And each project has been doing things on either their particular parcel or and has plans for the future for that. Question that I have for you is that essentially a future maybe question, or maybe regarding this question, is it should petitions or land use commission petitions be such of a large magnitude in the future? Or should they try to limit or be bifurcated at the time of filing to make sure that this type of multi-level projects, which makes it difficult for everybody to follow and what standards that we have to meet. I noticed in some of the filings that were made that there are certain conditions that it's not their responsibility, so they're not required to report on that, and there's certain that the other people are required to report on that. So my question to you is essentially, is this just too big a boundary amendment to really understand, to grapple, and to get a hold of, and to really manage?
Well, you know, if a project like this were to come at you in pieces, then you may have questions about what is this landlord going to do, or what is, you know, what are their obligations, and how, and if they're interacted and they're connected, I can imagine a lot of questions will come, and you know, one landowner bringing a petition with just that landowner's portion just may not be able to answer all your questions. The EIS, for example, would probably need to include everything, right? So, you know, when they bring the EIS, the proposed final EIS or EA to you for consideration, you're going to have questions about everything, and then they're going to need to be able to answer your questions and so forth. So I see the attractiveness in just bringing a portion. I would like to do that. That'll be easier, I think, but I can see the practical difficulties in trying to do it piecemeal.
One follow-up. So would it be a good idea or something to consider of bifurcating this particular matter?
You know, that would be you know, that would be like divorcing after decades of marriage. I mean, there's so many issues. And you got multiple landowners. You got 4 different landowners. They gotta agree. I mean, I don't wanna come here and then they're fighting, you know, we file a motion to bifurcate and they fight us, right? I mean, that's gonna be a mess. So, I mean, I understand the idea and, you know, we'll have to think about it internally and then discuss it with the other landowners. If that's something they're interested in. It's definitely gonna cost more in attorney's fees. And nobody likes to pay those, right? So, it's to be determined, I think, if that's a good idea or something that's even agreeable to the landowners.
Thank you, Mr. Tabata. I just was, these are the things that come to mind when I was reading all the different documents in this matter. And the other thing too is that, you know, I don't mind attorney's fees being paid to you by somebody else.
Understood, thank you.
Commissioners? So I have one question, and it's a hypothetical. It's a very general question. It's not specific to the particular project, and it's for Mr. Kwan. So Mr. Kwan, everybody, and I mean the residents, citizens, policymakers, et cetera, are looking for, where's the vertical construction? I understand that. And I presume that you get asked that all the time in your business. When are we going vertical? But I'm also struck by the incredible challenge that developers like Haseko have with all the upfront work that needs to be done on infrastructure and permitting and coordination. If somehow that challenge could be relieved or softened, can you envision a way that that can be done in such that would make your part of the job and getting these things going vertical sooner, faster, better?
Peter Kwan. Since we purchased the property, through today, you know, we've been working on a number of things that have to be done before we can get to the commencement of vertical construction. And actually, one of the precedents to that is even the infrastructure construction, you know, even mass grading before that, and then building the roadways and extending the existing utility system up into our development. You know, all of those things have to take place first, before we start doing the site work for the areas that we will actually be building homes for. And again, probably kind of repeating Commissioner Okuda's comments, you know, it's not meant to point a finger at anybody or put any blame anywhere. You know, we have a system, you know, we try our best to work within it. We know we have to do a lot of planning. You know, we do a lot of conceptual planning. We try to lay out our site, lay out where the roadways are going to be, how we're going to distribute the homes within the residential areas, and even how we're going to do a mix of various types of homes within those areas. It takes a lot of planning. Once we can come to decisions on that, obviously we will get into design and have our, you know, civil consultants designing our roadways and utilities and infrastructure. Our architects designing the various types of models and units that we will be building to be homes. You know, part of that process that takes time. And then we also know there's also subdivision actions that have to take place. And then obviously the permitting aspect of it, where we try to make sure we get all of our grading, trenching, building permits approved and in place before we start construction. You know, I can go on and on about those steps, but you know, most of you are probably familiar with that. You know, what we've been trying to do is try to get our plans in place and set as soon as possible so that we can direct our consultants to start actual design work, which we have been doing, for the purpose of getting permit plan sets in for permitting with DPP and whatever other agencies need to review them as quickly as possible. And also trying to insert enough time in our master schedule to account for a reasonable amount of permit review and approval time to try and hit the dates that we're setting in the future, where we're going to commence with vertical construction build the homes, and then go ahead and plan for, certificates of occupancy and ultimately closings on our homes and have people start moving in. So I don't know if that really answers your question, Mr. Chair, but we've been trying to work within, what we're very experienced with in terms of how long things take, doing the best we can. We have a well laid out and detailed schedule for our development, actually for all of our properties. And we're trying to utilize all of our experience to hit our deadlines so we can start delivering homes as soon as is practically possible.
I want to thank you for that. Because I'm not sure everyone in the world appreciates all the work and the time, the cost that goes in up front before you can go vertical. But you've described part of it. I don't know how to remedy that situation. We have a system in Hawaii and we try to do the best we can, and Haseko has performed in its own way very well. My last question related to that is, everything you described has a cost. Is it true that that cost somehow has to be recovered through the pricing of the residential properties that are for sale?
Yes, that is correct.
And doesn't that put greater challenge on actually delivering homes on an affordable basis?
It does. But I think that's why it's important that we have a mixture of, market priced homes, I guess what you call workforce housing for homes, and also the required percentage of affordable homes mixed in as well. So that hopefully overall, once at the end, when everything's been sold, we manage to cover our costs and make enough money to stay in business so we can continue to produce homes for Hawaii.
Fair enough. Thank you. Anything further, commissioners? Commissioner Lee.
Thank you, Chair. Since you brought it up, there is, as you all know, an alternative method, which is that the government provide the infrastructure instead of the marginal developer being required to assume the cost of all of that. If there's state planning, if there's county planning, Kakaako is one example of that. They spent $250 million for infrastructure. And then look at it now. It still took a lot of time, but it took a lot of the costs and uncertainty off of the developer. So I just wanted to share that. Thank you.
Thank you, Commissioner Lee. That's exactly where my mind was going. For those who couldn't read my mind. I'm going to take a break at this time. It is 10:44. We'll come back at 10:55, 11 minutes. $10:55, we're back on the record. Let's go to Ho'ohana Solar. Ms. Lim.
Thank you, Chair. Good morning once again, Commissioners. I'm Jennifer Lim, representing Ho'ohana Solar One LLC. I assume that you've seen it, but I'll just mention it for the record. We did submit a voluntary status report in anticipation of this hearing, and that was on March 18th, 2024. And in that status report, we've tried to provide the Commission updates on.
Please speak directly into the mic.
I'm going to move it closer.
Yeah, please do.
Updates on our compliance with the B conditions. As the Commission is familiar, when the decision and order came out in November of 2021, it set forth two separate sets of conditions. The A conditions apply to the landowners. We are not a landowner, we are a lessee. And the B conditions apply to the solar farm developer who is a lessee on parcel 52. So that's why the status report that we submitted addresses the B conditions. So I want to be respectful of everybody's time. I'm not going to obviously read through the status report that you've all had a chance to look at, but I'll touch on some highlights. I also want to remind the Commission that I have Mr. Green here with me, who's been working on this project for years, and certainly there'll be times where you may have detailed questions about project development. And I think Mr. Green would be better suited to answer some of those questions.
So let's take this moment to reintroduce Mr. Green, and let me swear you in.
Hello, this is Lawrence Green.
And your affiliation.
I am Senior Vice President with 174 Power Global, which is the owner of the Ho'ohana Solar One company.
And do you swear your testimony today will be the truth?
Yes, I do.
Okay, Ms. Lim, please proceed.
Thanks, Chair. So let me just, like I said, touch on some of the highlights on Ho'ohana's satisfaction of conditions. And I'm not going to follow them in number sequence because I think probably condition 1 and condition 5 would be of most interest to the commission, but of course we can go over all of the conditions. So when I say condition 1, I'm talking about condition B1, and bless you. Condition B1 required that if the solar farm were to go forward, that the solar farm developer, concurrent with construction of the solar farm, would provide a non-potable water line that ran from Reservoir 225 down to the top of the Department of Agriculture property that we saw from Mr. Tabata's exhibits earlier today. Condition B1 also required that Ho'ohana, as the solar farm developer, obtain from our lessor, Robinson Kunia Land, a non-exclusive easement in favor of the Department of Agriculture for that water line. So as I'm happy to report that the water line was completed, the water line runs from the reservoir down to the boundary of the Department of Agricultural property. And as we filed as exhibit, I called them H1, H2 for Ho'ohana. Exhibit H1 is the non-exclusive easement that was granted from Robinson Kunia Land as the landowner to Department of Ag. And just so that the commission's not confused, the Robinson Kunia land that's burdened by that grant of easement is not the same Robinson Kunia land that's within this petition area. So you saw that there's the petition area that Curtis was showing, Mr. Tabata was showing earlier, but north of the petition area is also a large parcel owned by Robinson Kunia Land. So the easement runs along there. The water line goes along Kunia Road until it gets to the Department of Ag. So that's condition B1. I'm also now going to flip to condition B5, I believe it is. And that's because I think that this would be of most interest to the commission. And that's that the solar farm had to be substantially completed within 2 years of the date of the decision and order. So as you know, the decision and order was issued November 1st of 2021. This commission, I mean, if we think back to what it was like in 2020, 2021, even 2022, with COVID, it was a pretty crazy time. This commission got together when we approached and asked for permission to pursue that solar farm and gave a good hard look and, thankfully authorized the project to go forward. So in the 2 years since the order was issued in 2023, the project, the solar farm.
2021.
I'm sorry. Thank you. Since 2021, the project has been, I would say, more than substantially completed. It is not yet providing power to the HECO grid. And Mr. Green will be able to speak to, specifics if you have on that. But at this point, just because I think a picture speaks 1,000 words, probably better than I do, I'd like to go onto the Zoom link and share screen just so that some of the photographs that we filed as Exhibit H5 can be looked at. Is that all right?
Yes. These are the same photographs that were in your
They're the same photographs that were in the status report.
Yeah.
Mr. Green just reminded me, those photographs were from a month ago. So that's because Mr. Green, there are drone shots taken of the site approximately the first week of every month. Yeah. So those were the most recent photographs we can get at that time. Yep, I'm just waiting for it to launch. Let's try it again. And to remind the commission, this is a 52 megawatt solar farm. So I don't believe it is the single largest solar farm in the state of Hawaii, but it may be the largest or certainly one of the largest on the island of Oʻahu. And I'm just waiting for it to connect again.
Recording in progress.
Okay. And what I'm pulling up, let me put mute on the computer, otherwise you're all going to hate me. Okay, what I'm pulling up here, let's get to get this to share, and it wants to share something else. Okay, here we go. Sorry for that delay. So what you're seeing here is the Ho'ohana solar farm, the 52 megawatt solar farm with battery energy storage station. So this is, well, if you can see where I'm moving over here, this is Kinea Road up along here. You can see that the panels, all of the panels here are in place. All of the equipment is in place. Over here, and again, can commissioners see where I'm wiggling the cursor? Over here is where the solar farm connects to the HECO KV line. Let me move down. Picture, here's another angle of the solar farm. Again, you can see that it is certainly substantially completed, and I would say more than substantially completed. Another angle of the solar farm, again, different perspectives, but all showing the same thing. All photographs taken around the same date, which was March, I think early March 3rd, something like that, March 5th. And this picture here, you know, if I could, I'm going to turn the microphone to Mr. Green, and maybe you can walk the commissioners through what they're seeing in this particular picture.
Certainly, Lawrence Green. What you're looking at on the left of the photograph is the Ho'ohana Solar One project substation. This is the facility where all of the electricity from all of the panels comes together and is stepped up from 34 kV, 34,000 volts to 138,000 volts, which is the voltage of the Hawaiian Electric system. To the right, the larger rectangle area, that is the Hawaiian Electric switch yard. And so that is the area that is directly connected into the Hawaiian Electric grid, 138 backbone grid on the island of Oʻahu. And so our electrons from the solar facility will run from our substation across the fence into the Hawaiian Electric switch yard, and from that point will serve the Hawaiian Electric grid. In the background, you see area that is right now, actually, this was a month ago, so now it's actually under construction with the batteries. As we mentioned, this project includes both solar panels and batteries. So the construction is now ongoing just adjacent to these two facilities. And then, of course, the previous photographs were further away, zoomed out, and that shows the location of the solar panels at the facility.
So the solar farm has been substantially completed, and it was within 2 years of when the commission issued that decision and order, November 1st of 2021. Now, the commission had authorized this project to be in place. There's sort of two options, okay? The project can be in place for 43 years from the date of the decision and order. So that would be until November 1st of 2064. And that's certainly Ho'ohana's intention, is to keep it in place. It's taken roughly $200 million to get what's built there right now there, and a lot of permitting and a lot of work, as I think many of the commissioners are familiar with, all of the hoops and the difficulties in getting something constructed. So, and the materials have a useful life that certainly would survive till that termination date. However, when the commission authorized that 43-year term, the commission also said, okay, you can have it there for those 43 years, but, and this you'll see in, I believe it's condition B7, but if Ho'ohana doesn't have a power purchase agreement, whether it's a new power purchase agreement, an amended power purchase agreement, something of that sort that extends the current power purchase agreement, then Ho'ohana would have to decommission the project by December 31st, 2047. So our deadline for entering to that new power purchase agreement is December 31st, 2045. So what that means is the project is in place, the commercial operation date is right around the corner. And again, Mr. Green can address that more fully if you'd like. But that's a 20-year power purchase agreement. And so that's for sure guaranteed. And then again, before that 20-year term is up, Mr. Green or his successor, at the company will be pursuing an extension through with HECO. And if the PUC were to approve that, then the project, there's every reason to believe that the project would remain in place and then be fully decommissioned by November 1st, 2064. So that's a summary on what I believe would be the commission's highlights, the things that I think you would be most interested in. But I can also touch on the satisfaction of certain other conditions, and I'll do that very, very briefly. Again, wanting to be respectful of everybody's time. But in approving the project in 2021, the commission, in addition to the condition that we talked about regarding the non-potable water line, also imposed a condition regarding fish and wildlife, basically a biological condition. And it's several parts, and it was actually a condition that I believe OPSD had a great deal of input on. As reported in the status report, and again, I can pull up the relevant exhibits if that's of any interest, but all of that has been satisfied. PUEO survey has been done. I would say at least as important, if not even more important, is that the contractors were given a full briefing from the biological environmental consultant, ACOS, on what to do, what to look for, what to do if you see them, don't disturb nests, don't have lights at night. All of that's provided. I believe it's our exhibit H2. So that was a training that the contractor and staff had to go through before they could start doing stuff on the property, start, doing the grading and doing the groundwork. I'll move quickly now to condition B3. Now, B3, there's not much to say there. It's an important condition which said that no ground disturbance could happen until SHPD, that State Historic Preservation Division, had given its clearance. SHPD has given its clearance. Again, that's in the record with the status report at exhibit H3. So no ground disturbance took place without SHPD's blessing. Condition B4 was the condition to address the risk of there being any flight hazards. And so again, there's a few details in there, but essentially a glint and glare study had to be done. And if there were any issues with glint and glare affecting air traffic control towers or affecting the airplanes, then Ho'ohana would have to address that. In fact, and you'll see this filed as Exhibit H4, the FAA, Ho'ohana did the glint and glare study. The analysis was done within the FAA, and the FAA confirmed that there was no interference arising from this project. Going now to condition B7. We already spoke about B5, which is the 2-year substantial development. Condition B6, I feel, is a bit redundant because it's the compliance with representations and specifically mentions non-potable water line. And that has been built. Oh, I just realized there is one statement that I want to make about that. It's built and the easement's been granted. But there's a further part to that condition, which is that Ho'ohana has to maintain that water line for the duration of the solar farm. And again, Mr. Green will confirm, but Ho'ohana will be maintaining that water line. Is that correct?
Yes, Lawrence Green, I confirm that we will maintain the water line for the duration of the solar farm.
And with that, I'll just move to condition B7, which is the last of the conditions applicable to the solar farm. And that's primarily about decommissioning. And that's where you also have that time frame that I mentioned earlier about if the PUC doesn't grant a approval of a further or extended PPA, then the term of the solar farm would be shortened from what the commission had originally authorized, which was 43 years. So with that, again, we're both here and we're very prepared to answer any questions that you may have, but I'd like to be quiet now and see if there's information that you specifically would like to hear from us.
I'm going to turn it over to commissioners' questions, but you mentioned COD or commercial operation date. What's the current forecast for that?
We're currently scheduled to reach commercial operation on October 31st of this year.
October 31,
Correct.
and that's with the BESS.
Correct.
And the capacity of the BESS.
52 megawatts, 208 megawatt hours.
Thank you. Commissioners, further questions? I don't see any questions. We're good. Thank you.
Thank you, commissioners.
Okay, let's turn to RK2 Partners for your report.
Thank you, Chair. Commissioners, Terry Lee, co-counsel for RK2 Partners. To my left, Derek Kobayashi. Also, we have David Snoy from RM Towel, who is the engineering and planning consultant for the client, as well as Eric Elkind, who's co-counsel, and Ernie Martin, who's also co-counsel.
So should do you plan to use Mr. Tuck
No,
to represent?
not unless the commissioners have questions.
Okay, proceed.
We were recently engaged, and so I've spent a considerable amount of time reviewing a lot of the past filings in this petition and trying to understand the history of it. And I want to start by apologizing to the commission and the staff for being delinquent in filing our 2023 status report. It was filed yesterday, and I suspect because of the late filing, many of you may not have had a chance to review it. Essentially, because our project is just the industrial piece, which involves some light industrial use and some commercial uses, much of the conditions in the 96 order and the subsequent amendments to that order really fall on Haseko. Affordable housing, a lot of the infrastructure improvements, roadways, utilities, drainage, We have some obligations relative to designing drainage through our property for the benefit of the Department of Ag. And the other area that we owe an apology to the commission is we're supposed to have filed a revised master plan for our project. And we have not done that yet. We know how we want to develop our roughly 124 acres. The problem we have is the timing. And the reason is because, and I'll give you a perfect example. We have pending with DPP a subdivision application for 37 acres, which is phase one of our development. Unfortunately, as part of that application, we're piggybacking on a subdivision application by Halekua, which is to create road, but Fiscal in its earlier presentation described as Road Y, phase one, which they indicate is going to be done by 2026. Well, DPP needs to first approve that subdivision application before it can continue processing our subdivision application. And so my point is, our ability to develop our project is heavily dependent on, Halekua completing certain things. And we are in discussions with Halekua, as I understand it. We may not necessarily be in agreement on the timing of when they're supposed to perform certain things. We do have what we call a second amended and restated infrastructure agreement. Second ARIA is the abbreviation for it, that has certain deadlines for these roadway and utility improvements that Halekua committed to perform. I don't want to get into the nitty gritties of our contractual disagreements necessarily, but suffice to say that we're engaging in earnest negotiations with Halekua. We want them to move quicker so that we can then move forward with our development, and we're hopeful that we'll work something out with them. So having said all that, we're available for any questions the commissioners may have, but I think, I'm sorry, and then one other housekeeping matter. And it relates to a December 23rd, 2004 order that the commission entered concerning a motion by the Office of Planning to accept certain terms that were stipulated between our predecessor in interest, which was HRT, the Weinberg Foundation entities, where in order for the then owner of the property that Halekua now owns had an obligation to acquire 150 acres and to convey it to the Department of Ag. They ran into financial trouble, so HRT committed to acquire that 150 acres on its own dime and convey it to the state. As I understand it, in exchange for that, they negotiated an understanding with the state that if they do that, that in any future proceedings, unless HRT itself violated or didn't satisfy conditions relevant to its industrial property, the roughly 124 acres, absent that, failure of other parties to satisfy conditions of the reclassification would not cause HRT to lose its designation, its urban designations, that it can, in other words, it's sort of protected from that downside risk. And the ultimate order that came out of the commission is somewhat vague in terms of whether the protection granted only relates to the particular order to show cause that was issued back then, or whether it has longer legs and goes out indefinitely into the future. And it relates to your questions about bifurcation and all of that. So for us, it would be helpful if the commission and perhaps, Mr. Morris as counsel to the commission can clarify for us exactly what is the legal effect of that order, because it will then help inform us moving forward on exactly, how we file our future status reports, how we deal with the issue of whether we support or oppose bifurcation, and also whether, how we negotiate with our fellow landowners on how certain conditions get satisfied. Because obviously, if we're not at risk of losing the urban classification, if Haseko, for instance, fails to satisfy a certain condition, then, we have less at stake, if you will, other than the fact that we need them to perform certain things so that we can move forward with our development. But at least we're not going to lose the fundamental urban classification we need for our project. And so, that's a request I'm asking of the commission.
Understood. 1 second. Bit more than a housekeeping matter, I might say, in response. But on that last, what you termed a housekeeping thing and a request of this commission, that's beyond the scope of what this commission can do at today's hearing. If you specifically want clarification on that, you need to file a petition for a declaratory ruling with our commission. We will take that under consideration, agendize it, and proceed. But that's the proper way to resolve that.
Thank you. I appreciate that. And I wanted to explain this situation because, it is relevant to, our status report and exactly what we report to the commission and the scope of it. So, having said all that, we have filed a status report. Most of the conditions that we address, basically, pass the buck to Haseko, if you will. And to the extent we have obligations, which, as far as I can tell, really only relate to, drainage improvements within our property for the benefit of the Department of Ag. I don't think we have any other specific requirements that we need to meet beyond that. Thank you.
Thank you. Quick question for staff. Has this status report been posted yet?
Staff did not receive the status report because we were setting up this venue at 2:00. Was it sent after 2 p.m.?
Anyway, it's not posted yet.
Not posted yet.
Okay.
Yeah, I believe it was electronically filed sometime after 2:00 yesterday. Yeah.
Yeah. So thank you. Obviously, we strongly encourage you to be more timely in your filings and not miss deadlines as we go forward. So appreciate your following through on that. Can I have your commitment that you will follow through on a more timely basis?
Yes, absolutely.
Thank you very much. Okay, commissioners, questions. Commissioner Okuda, I see you leaning forward to the microphone, so I'll call on you first.
Thank you very much. Good to see you again, Mr. Lee. This goes to your comment that the buck is passed to Haseko, yeah? And I'd just like to kind of inquire a few things, or ask a few questions regarding that. Much of this may be taken up in a petition or motion for declaratory relief in the future. But if I can raise these questions anyway, since these were raised in this status report, do you agree that the findings of fact, conclusions of law, decisions and orders, and amendments regarding those items filed in this docket became and are encumbrances on title?
Yes.
And of course, your client, before it purchased or acquired its interest in the property, did a certain amount of due diligence, correct?
Correct.
And part of that due diligence is ordering up a title search to determine what encumbrances are on title, correct?
That would be my assumption, although I didn't represent them in the acquisition, but
Okay.
I would assume that was the case.
Yeah, and anyway, you know of no evidence that indicates that wasn't done, that the normal due diligence didn't take place, meaning order up a preliminary title report, look at the encumbrances, and in fact, order up copies of those encumbrances and read the documents so that before the purchase was made, your client would understand everything that it would be subject to regarding the property when they purchase whatever they purchase, correct?
That would be a usual and customary due diligence process.
Okay. And do you agree that the Land Use Commission orders that have been recorded are encumbrances which, as we in the law say, and I quote this phrase, run with the land, close quote?
Yes, I would agree with that.
And what is the effect, in your understanding, of when a encumbrance runs with the land?
Well, basically, to the extent, it's a recorded encumbrance that runs with the land, it means that it binds successor landowners.
Okay, and let me read this one sentence from the Waikiki Malia Hotel Incorporated versus King Kai Properties Limited Partnership case. Again, I had mentioned earlier, that's found at 75 Hawaii 370. This is specifically from pages 382 to 383. And after I read it, my question to you is whether what I read is an accurate statement of the law. Okay, quote, a covenant is viewed as real in nature or one that runs with the land where either the liability to perform the duties therein enumerated or the right to take advantage thereof passes to the vendee or other assignee of the land, close quote. Is that an accurate statement of the law as I've read it?
Yes, if it's a recorded covenant, that's correct.
So in other words, the duties that were enumerated in the original Land Use Commission orders, these were duties that were imposed and frankly agreed to by the owner of the entire parcel, correct?
Correct, the entire 500 plus acres. That's right.
And your client succeeded to a portion of the property, correct?
Correct.
So in other words, if for some reason, and I don't really foresee this, but as just a question to flesh this out, if for some reason Haseko doesn't perform its obligations, then there's a reasonable argument that can be made that under the Waikiki Malia case, your client might have to satisfy those obligations.
That is a legal risk subject to the petition for declaratory relief that we will file.
Yeah, that's correct. But as things stand right now, on the record we have before us right now, because that's all we have, I wouldn't be violating, as they say, Rule 11, which, would sanction me as a lawyer if I filed, frivolous, bogus kind of lawsuit or petition. It wouldn't be a Rule 11 violation to basically make the argument that your client would be responsible to carry out the obligations of Haseko if Haseko doesn't perform, or any of the other obligations which are set forth in the various land use commission orders, correct?
I would agree with that, yes.
Yeah, so it actually, and I'm not saying you folks aren't cooperating with Haseko or anything like that, but it's not simply passing the buck to them. It might be, if you see maybe somebody about to drop the ball, a cooperative effort might help move this entire development along, correct?
That's a fair statement.
Yeah, okay. Thank you, Mr. Chair. I have no further questions.
Thank you, Commissioner Okuda. Commissioner Oikashi.
Mentioned, Mr. Lee, you mentioned that you haven't filed a master plan, but you kind of get an idea of what you want to do. According to your statements, you have filed a 37 lot acre subdivision, and is that part of your master plan that hasn't been filed yet, but you kind of know what you're going to do?
Yes, and again, forgive me because I was just recently engaged, so I'm absorbing a lot of information from the client, but based on what I've learned so far, the phase one of their development is to subdivide 37 acres of the 124 acres. And I have a copy of the proposed subdivision map that was submitted to DPP. And it looks like they're creating roughly 11 industrial lots, along with some roadway lots and so on. But 11 industrial lots that they could then sell or lease or what have you.
So my question is, do you have then do you have then a master plan, just not filed with us? Or are you just piecemealing the project as you go along? When one of the conditions, I believe, was that you file a master plan with this commission.
I'm sorry, I can't answer that question because I'm not involved in the planning. Maybe, if David Tanoy, if he's still here, he may know. What I understand is conceptually, the client has a plan of how they want to develop the 124 acres in phases. Again, the first phase is just 37 acres, but beyond that, I don't know how specific their planning has been done to date. But we recognize the need to create a revised master plan and submit it.
Could you give us a timetable when that will be done?
I could not. I'd have to confer with my client and RMTAL.
Do you know when the revised master plan was due?
If my memory serves me correct in reviewing the amended orders, I think it was several years ago.
And so I would generally comment that when has Royal, what was it, RK2 Partners, when did they acquire the property?
They acquired it in November of 2021.
Okay. So my only comment is that it would appear that part of your request to this commission in the future would be to modify the date that the master plan would be submitted. Wouldn't that be a fair amendment to a condition?
Yes, I think that's a fair observation.
And the second thing too is that before any party would involved in this matter, given it's so complicated and so many owners, perhaps the comment about not meeting conditions should be looked upon individually before speculating what might happen in the future. In other words, if you're going to say that you don't want to be subject to their conditions, they're subject to your conditions. So technically, the rest of these people here are in breach because failure to meet that condition. Would that be a fair statement?
You know, I'd have to think about that a little more because of the,
It's just for thought.
yeah, it's a pretty heavy
Thank you
question.
so much.
Yeah, thank you.
Thank you. Commissioners? Two things. Can I ask that you confer with your consultants during the break, and when we come back, that you give us a commitment, at least an estimate, of when we'll see a master plan from you?
Yes, I will do that. Again, however, you know, part of what the,
I said estimate.
yeah, yes, but I was just gonna clarify that part of the revised master plan, you know, requires us to have certain deadlines as to when things will be done. And so we could estimate deadlines, but we'd have to have a footnote that it's dependent upon, you know, the efforts of others such as Haseko.
Sure, that would be clarifying assumptions that would be incorporated in your plan.
Yes.
And then I had a question back to Mr. Tabata. There were representations in the testimony about an ongoing negotiation between the Haseko and RK2 Partners, where RK2 Partners is saying to us, to the commission today, that they are dependent upon certain things proceeding in a timely manner or in an understood manner. Could you give us, from your perspective, an update on the ongoing relationship and this so-called or referenced negotiation?
My understanding is that they're in negotiations. There's an ongoing discussion, which I'm not involved in, so I can't give you the details. But I did read Mr. Kobayashi's filing, and you know, they're, and I don't have anything to dispute the fact that they are currently negotiating. So,
Mr. Kwan, do you know anything more about this?
Peter Kwan. Yes, we have been in discussions and meetings with the RK2 Partners team since early last year. Sharing information, schedules, trying to provide updates on progress made on each of our respective developments.
Is it your understanding that their subdivision application with DPP cannot proceed until yours is complete?
I believe the one that he's referencing is actually not dependent upon Road Y Phase 1, which is what I think Mr. Lee mentioned. It's actually, it abuts our Road X Phase 1 along that northern boundary that runs from east to west between our properties. That subdivision map of ours is in process, and it'll be submitted probably sometime this month, along with the Road 3, which is that other road that runs north-south on the west side of our parcel.
Thank you. Okay, back to you, Mr. Lee.
I stand corrected.
So will you restate your corrected interdependence on Haseko subdivision?
Well, we're still dependent, but rather than Road Y, it's Road X.
Very
I
good.
just had the designation wrong.
Yeah, and your master plan will represent that.
Yes.
Okay, great. I don't have anything further, commissioners. Thank you very much. We'll now go to RKS for your report.
Thank you, Mr. Chair, Commissioners. As far as our status report, I think all of the information that has been provided to you by Juana and Seiko pretty much cover really the status of our project.
One question. Are you counsel for?
Yes,
Yeah.
Stephen Mao, I'm counsel for Robinson Cunha Land LLC. And basically, we have been working with the Seiko. We think we have all agreements necessary for the Seiko project to proceed. And we have for the next 20 to 40 years committed the property. So we have no revised master plan. We at some time when the future use has to be considered, I think the commission has already requested a rule that we need to come back with a revised master plan at that time, and we will do that. But I have nothing further to report other than what was mentioned in the Juana report as well as the Seiko report, and we concur with the report as filed.
Commissioners, any questions for Mr. Excuse me, Commissioner Carsmith?
Thank you. Just trying to understand. So Robinson Cunha Land LLC is the owner of the parcel where the solar farm is, correct?
Yes, that's correct. We sometimes refer that as to the increment 3 parcel, but we do have a lease with Ohana to lease the property for solar purposes.
And are you also RKES or no?
Not RKES. The owner of the land is Robinson Cunha Land LLC.
All right, thank you. Chair, I was just trying to understand who RKES is.
So am I.
Okay, thank you.
Let me ask staff, who's RKS?
Is that the school site?
Thank you, Chair. That was one of the purposes of this hearing, because that staff is unclear from what's on record, who the owners are and who the participants are.
So Robinson, could you please state for the record your legal name as owner of what property and what is the current state of that property?
Yes, Stephen Mao. I am the counsel for Robinson Cunha Land LLC. Robinson Cunha Land LLC is the owner of what I'll refer to as increment 3. The entire increment 3 parcel is leased to Hoana for solar purposes. Robinson Cunha Land LLC also happens to own the property that's north of the petitioned area and the ag park. And we also own the reservoir 225, and we did give an easement over the Robinson Cunha land in order to put in the water line from the reservoir, Waiholi Reservoir 225 to the ag park.
Thank you. I think I understand. How about you, Commissioner?
Not really. Do any of the petitioners know who RKES LLC is? That I believe, based on your exhibit, which I like, Exhibit 1, that's the school parcel, right? You know, who is that?
I think that is the school site. No.
They want to know.
Oh, yeah.
Peter Kwan. Yes, Commissioner. RKS, as we understand it, is the owner of the school lot. I believe they are entity under the Kobayashi Group.
Thank you.
Are they represented here today?
Not sure.
Is anyone here either the owner or council representing RKES, which is, we believe, under the Kobayashi Group, and it's related to the property associated with the school?
That's correct.
Okay, so let me ask staff to follow up with them independently. Thank you for that. I think we figured it out.
Okay.
Thank you, Commissioner Carr-Smith, for bringing that up. Commissioners, Commissioner Okuda.
Thank you, Mr. Chair. Mr. Mao, this is the similar question or same question I was asking the other attorneys and parties. Given the fact that the various parties here are successors in interest to the original applicant, and there has been no bifurcation or separation as to the original application, do you agree that, first of all, the conditions and provisions of the various land use commission orders, the findings of fact, conclusions of law, decision and orders, as they may have been amended, are encumbrances which run with the land?
That's correct, Ms. Okuda. I would point out, however, the original petition and memorandum that was filed did encumber the Robinson land in a very limited manner.
Okay, but would you agree that unless and until there's a clear bifurcation, and just so that we're clear about the language or the meaning of it, where responsibilities are clearly separated and divided among the parties, unless you see a clear separation or release from the Land Use Commission of these responsibilities or obligations, the responsibilities and obligations are joint and several.
I would agree that there are conditions in terms of obligations. I'm not sure I would agree with that.
Okay, what legal authority do you have which would support your statement right now?
That the encumbrances that were filed against the property were conditions.
Okay, well, let me clarify, and I'm sorry if I misstated something. Would you agree that the obligations to do certain things, like for example, the obligation to the Department of Agriculture to perform or do the things required with respect to the creation and support, for lack of a better term, of the agricultural park, those obligations are joint and several?
Those are conditions on that encumber all the properties. That's correct.
So, for example, if the condition required construction of certain infrastructure, and let's say Haseko did not complete the required infrastructure, would you agree that the other landowners would also be responsible to complete that infrastructure?
I would agree that those are conditions and that you probably would have an order to show cause, and you would probably take whatever action you thought was appropriate.
Okay, thank you very much for your answer. No further questions, Mr. Chair.
Thank you, Commissioner Okuda. Commissioners, anything else? Thank you very much.
Thank you.
So I'm going to shift the order now to the Department of Agriculture. Can you give me an indication of approximately how long your commentary or presentation will be?
I don't think very long on my end. However, if the commissioners have questions, which I anticipate you all do, that might be longer.
Okay, please proceed.
No. Kelsey Nagata, Deputy Attorney General for the Department of Agriculture. I also have with me Brian Call.
Should I swear him in?
He is available for to help me answer any questions, or if he has the better answer for any
Let's do that.
factuals. Yeah.
Mr. Lau, is it Lau?
Call.
Mr. Cow, would you please introduce yourself, your affiliation, and then I'll swear you in.
Brian Cowell, Department of Agriculture.
You swear that the testimony you may give today will be the truth?
I do.
Please proceed.
For some brief background, I'm sure many of the commissioners already know the department and the department's goals. But the department has 150 acres in this area of prime land in Kunia that's slated for the development of an agricultural park. The department's plans for this parcel will result in 24 farming lots, each lot about 5 to 7.5 acres in size, for farmers to enter into long-term leases with the state. The importance of this land cannot be understated. It's ideal for diversified agriculture with highest classification of soil for farming. The site will also have access to reliable irrigation water, moderate weather conditions, and strategically located for product distribution. This is very important for the state and the self-sufficiency of agriculture. Just for context, on Oʻahu, there are 4 subdivided agricultural parks, not including the Royal Kunia Agricultural Park right now, which are Waimanalo, Kahuku, Kalailoa, and Waianae. They are all presently leased out in long-term leases to farmers. And when the leases do, in fact, go back out for bid, there are always many applicants who apply for the lots. In the only other way for farmers to get on the land in one of these agricultural parks is to buy out the current tenant and the current lease, which often precludes new farmers who may not be established financially. And this would, therefore, addition of the new individual lots in the Royal Kunia Park would greatly benefit the department and the farming community. So presently, the department has been unable to prepare the land for development and subdivision because we were waiting for past obligations to be fulfilled. It's the department's responsibility to develop the infrastructure within the agricultural park, which we are willing and able to do so. The new amended MOU between Department of Agriculture and HASECO is what we believe is a really good step in the right direction. As it demonstrates for those who haven't read it yet or who have read it, it is Exhibit 9 of HASECO's motion. Notably, HASECO and Ho'ohana are the only developers who have broken ground and installed the water line and is substantially completed in the past years that this project has been pending. Under HASECO's watch, additionally, the department has seen additional meaningful changes to develop that demonstrate HASECO and the other petitioners' commitment to honoring their obligations and the conditions under the Land Use Commissioner's order. Specifically, as I stated, the irrigation pipeline has already, installation has commenced and is substantially completed. HASECO is also bonding the offsite infrastructure in favor of the department, which is subsection F of the new MOU. And lastly, to answer one of the questions that was raised previously towards HASECO is why 2025. It was the date that was agreed upon between HASECO and the department, as which would be reasonable for the department to receive infrastructure, the basic infrastructure, to start subdividing and developing the agricultural park so that the state could start leasing out lands for new farmers. And I understand that the commission had a question of whether the department has applied for its seaworm permit application, a permit application for seaworm for water allocation, and the department has applied and is currently working with the commission to get its water allocation. The other question I believe that Chair posed was the consequences of no water or no electrical is simply that there will be no agricultural park. We again stress that the department needs this agricultural park to help develop and sustain agriculture in the state. And without the infrastructure for the water for the farmers and electrical for operations, there is no way for the farmers to farm. And I'm available for any questions.
Thank you very much, commissioners. Commissioner Uegashi?
Has leases been given out yet?
leases have not been put out for bid yet.
And when, if you anticipate the completion of the water and electrical to the area, what was it, 2020?
2025.
Yeah. December, well, what was the date? I forgot.
The permanent infrastructure, according to the MOU, is December 2020, or sorry, September 2028.
No,
The temporary is December 2025.
Okay, so, if you get that, how long till you advertise for leases, go out for leases?
It really, I mean, a typical lawyer answer, it depends. Of course, the department will need to continue to grade the land first and then subdivide the land and then make sure that our infrastructure is able to be installed to allow for the farmers to get the water.
Are you able to do all of this during the time prior to the issuance or the obtaining of temporary utilities and temporary water?
The department is able to begin what is in their control, barring any funds from legislature, including capital improvement.
So what does that mean? What is in your control? Your control is, you said grading and things like that. Are you guys gonna do grading, things like that prior to the water? I'm just curious, you know, it seems to me there's a deadline put on. Halekua didn't seem to know why it was important. It seems to me that you have an important goal to try and get these leases out and try and do that. And a temporary water and temporary utilities will help you do that. So I'm just trying to focus in on the DOA. When will that occur on some kind of meaningful basis? We're pressing all of these other guys for getting a master plan, you know, making sure that the solar is completed, you know, making sure Halekua gets all its ducks in order. We're just wondering, as a state agency, when can we expect leases to be issued?
I cannot commit to an estimate on when we can issue leases, but I can.
No estimate even.
The reason for the inability to estimate is because as the commission knows, the Department of Agriculture needs funding from the state legislature to complete similar capital improvement, which includes agricultural parks. The department has been asking for many, many years for funding from the state legislature and, doing our due diligence each session to ensure that we receive funding for the agricultural park. As I'm sure the commission knows, this year, money is a little tight on the legislative side and the budget, but we still continue to ask every year for the money necessary to develop and operate the agricultural park, including agricultural parks within the rest of the state.
My comment is just that, it's just that we're placing a lot of emphasis on developers spending money and trying to create this thing. And from what I understand, you're telling me that we haven't even gotten the legislature to buy in for the funding. And that's what your statement is, that the legislature hasn't bought into the funding. Is that right?
I don't want to speculate as to whether or not the legislature has bought in, because we have, again, done our due
Has the
diligence.
agricultural Department of Agriculture received at least initial funding for this project?
Several years ago, Brian Cow, Department of Ag, several years ago, and I apologize, I can't identify the exact session. We did receive initial funding to start to do the design work necessary to develop the ag park. So
Has
to
that been
lay out-
done?
I'm sorry?
Has that been done?
Yeah.
Okay.
So
So the next step is, what I'm trying to get is that we're putting a lot of pressure, a lot of money on developers to do these things. It would seem to me that the state would be beneficial for them as partners in this area, in this DBA, to expedite their portion of the conditions. And as Mr. Okuda would say, as Commissioner Okuda would say, all these conditions run with the land. And if you own the land, the state is part of the conditions. So you may want to consider making sure that these leases take place.
We understand and we appreciate the commission and, putting pressure on everyone equally, including us, to get the project moving forward.
Commissioner Okuda.
Thank you, Mr. Chair. This is follow-up questions to Commissioner Ohigashi's. So has the design for the agricultural park been completed 100%?
I believe it has been. I can't verify that it's 100%. We have seen final plans that we've signed off on. We do have the final layout of how we're designing the interior of the egg park. I do believe that the project is shovel ready.
Okay. And if the project is shovel ready, what is the next step that you have to do to put the shovel in the ground?
It's as soon as we receive funding, we can just bid out the project and start the grading process.
Okay, let me stop. So the next step is you have to get the funding, and that's funding from the legislature, correct?
Yes.
Has at any time, was there a request made to the legislature that you know of, not guessing, but that you know of, that has been made to get the shovel in the ground? You said you already had the funding to do the design. You have the design done. So was there a request made to the legislature to get the money to put the shovel in the ground?
Yes.
When was that made?
I believe the last request that made it to the legislature in the executive budget was the year before last. It was not in this year's budget.
Commissioner Okuda, may I
Yes.
quickly just clarify? Our understanding based on other reviews of very similar nature is that the departments put in a request to the governor's office. The governor then will put together an executive budget, and that's what's submitted. So you may or may not have been included in the governor's request. So it could lose out there, and then it could be forwarded by the governor, and then it could win or lose at the legislature. Is that the way the process works?
That is correct.
Okay.
We do submit it to the governor's office every year. It's one of the department's top priorities.
Thank you. Commissioner Kuda, please resume.
Okay, thank you for that clarification. That speeds things up. So as things stand right now, you don't have the funding for this agricultural park?
Not to start construction, no.
So following up what Commissioner Ohigashi asked, why should we put pressure on all the landowners here to, hurry up and spend money and do all these things if we might end up with the Department of Agriculture's version of the Halinoalani dorms?
I'm sorry, I'm not familiar with the project you're.
Yeah, that's the one University of Hawaii has left the Halinoalani dorms vacant for 7 years because apparently nobody knew it was being left vacant. I'm not just being facetious here. My question is, why should we then, and this is relevant to possibly tomorrow's hearing, why should we, as Commissioner Ohigashi said, we put all these pressure on these landowners or private parties to spend good money to get things put together when you don't even have funding for this agricultural park? What's the justification for us to to take that action if that's the action that's taken?
One of the questions that we get whenever we submit the request, and whether it stops at the governor's office or the legislature, is that exact question, but in reverse. So essentially what they're saying is, why should we fund you since you don't have the ability to get farmers on the land? Your infrastructure is not at your border. So it unfortunately, what seems to be happening is it's kind of a chicken and the egg thing. Somebody keeps on waiting for the other party to step up and do the first thing. And that's kind of what we're seeing.
Can you name anyone who has told you that funding for the Department of Agriculture to build or create this agricultural park is being held up because of the actions or inactions of Haseko or any of the other landowners with respect to this parcel of property?
I'm not able to respond to that.
Okay, thank you, Mr. Chair. No further questions.
Thank you.
Mr.
Mr.
Chair.
Yamane.
Thank you, Mr. Chair. Thank you for the update. Just wanted to clarify that without the temporary infrastructure, you aren't able to lease out the land. Is that correct?
Yes.
And I'm assuming that, I think it was 2025, that you're in some sort of communication where you're getting updates from the land developers as for the statuses of the temporary infrastructure. Or how is that process to be informed on where the developers are on the temporary infrastructure?
My understanding is that the department regularly meets with the developers to get status updates.
Is that like a monthly, quarterly meeting?
It's periodically.
Okay.
Yeah.
But fair to say that you guys are meeting regularly to get updates from the developer as far as the temporary
Yes.
infrastructure. And once that temporary infrastructure is there, then pretty much the legislature's question is answered as far as now you're able to support farmers on the lot, correct?
Yes.
Okay, thank you, Chairman. No questions.
Thank you, Commissioner. Mr. Carsmith.
Thank you, Chair. I'm trying to get some clarity about the water. So the developer, the Haseko, was required to provide temporary power and water, right? To the ag park? Is that the way I understand it?
That's a question for Haseko.
Yes. And let me just say a little bit broader. I'm trying to understand how Robinson Cunha Land LLC owns the reservoir that is next to the ag park. But then Haseko is required to bring the water down, seems like a long meandering way to get back to the ag park. But then there was also the solar farm that had a requirement for water. So I'm a little confused, if you can just clarify.
Excuse me, Stephen Mao. The water and the water line that was put into the Waiholi Reservoir, that's for non-potable water. And the water I think they're talking about to provide to the ag park is potable water. But I'll let Haseko respond more directly.
Peter Kwan. Yes, Mr. Mao is correct. So there are two different lines. The non-potable is being drawn from the open reservoir, and that will deliver non-potable water to the Department of Agriculture's northern boundary that they're going to use for agricultural purposes. The temporary infrastructure that we have mentioned includes potable water and functional power that they would like us to provide to them at their property line by December 31st, 2025, that they told us they intend to use for the agricultural lots.
And so is the potable water and the power needed for processing the crops? Is that?
Yes.
Yes. Okay. So it almost seems like the farm could proceed and have water to start the crops and with the idea that potable water would be available in 2025.
It is possible, depending on which crops the farmers grow. Lettuce often uses potable water, just because of health safety standards. So it is possible, but it really does depends.
Thank you all for clarifying.
Commissioner Lee.
Thank you, Chair. For the Department of Agriculture, could you clarify that even if the governor doesn't include money in the budget, legislators themselves can add that to the budget, and subsequently the governor may even, and if it passes the legislature, the governor could then also decide not to release the funds. Is that correct?
Yes.
Okay, thank you, Chair.
Thank you. Commissioners? Couple clarifications and follow up. So the governor submitted his budget to the legislature. I presume that's for fiscal year 25.
Yes.
So that's July 24 through June 25.
Yes.
Did that budget include any money for this ag park?
No.
So unless something happens along the lines that Commissioner Lee just described, it would be fiscal year 26, which would be July 25 through June 24, 26, excuse me, June 26, before you get any clarification or money to further develop the ag park at the earliest.
If it does not make it into the budget that is before the legislature today, then yes. However, the department does continue to work with the legislature to try and convince them to put it into this year's budget.
How much money are we talking about? Since you've clarified it in your request to the governor, how much did you ask him for?
I believe this year's request was for $10 million.
So we got $10 million that we need to develop this ag park at your expense.
That would be a phase one request for us. The development of the park does require substantial, just like Halekua was saying, before you go vertical, there's a lot of stuff that does need to be done on the ground in order to get lessees on the ag park. One of the things that needs to be done is some mass grading. And then we have to do with our own interior utility installations. So the $10 million is intended to get that part or a majority of that part done. We potentially and hope that we could get maybe about half of the tenants on the land with that initial 10 million, but we're not sure.
So you need 20 million.
That was the estimate that we had come up with.
Why don't you ask for 20 million? Get it done.
We've done that before in the past, and the figure is large enough that it causes some eyebrows to go up. And in an attempt to try and get it started, with some comment back from the legislature, we decided to try and go with a smaller request to try and just get it started, and then request subsequent years, additional funding on the subsequent years to finish it off.
Okay, I'm gonna shift gears. Is it fair for me to characterize the Department of Agriculture that it's had some frustration with the developers since the 1990s in fulfilling their obligations under the terms of the district boundary amendment prior to Haseko, and that since Haseko's taken over, that frustration has been somewhat relieved? Can you describe how the official or your perspective from DOA?
I believe that's a fair statement. There have been some frustrations over the years, but with, again, as I had stated, with Haseko and Ho'ohana's movement, in the construction of the water line, we feel that this is a step in the really, really, really good direction, and we are really grateful.
So I can see why DOA and the legislature itself and the governor's office would be hesitant to commit, funds when nothing was happening on the developer side. But we've got a clear indication there's something substantial happening now with the leasing, the solar farm, and with Haseko taking over the development of the housing. That should inspire the DOA to move forward more aggressively and convince those in the state it needs to fulfill your part of it. Otherwise, I see the frustration going 180 degrees to hear these developers have been asked to spend all this money to do all this upfront work, and they're finally getting it done. And now the DOA is not following through. So that's the frustration you're hearing in the last 15 minutes here from the commission.
We understand and we respect that. And this, since the start of the construction, the department has been working very diligently to try and work with the legislature to get funding, including with the governor's office, to help move the agricultural park forward and towards the overall agricultural self-sufficiency of the state.
Okay. Do you have, Mr. Quantin, do you have a master of the equivalent of a master plan with a timeline for this development?
I'm not sure how to answer that question. Could you? We have, as stated earlier, our design is complete, and provided we have adequate funding, we could get started as soon as we could get the construction contract.
So the earliest you can get the dollars, I think, is somewhere around the end of 2025. Real dollars, unless you got something some magical happens at the ledge in the next 30 days. Or 15 days, whatever it is.
Yeah, if it is included in this year's budget, which, it's a challenge, then typically CIP funds become available to the departments around September or October. So that would be on a year-on-year basis, right? So if we didn't get it this year, then next year, that's when it would be available.
So assuming that's the case, how soon could a potential leasee be expected to put his shovel in the ground? If you get dollars, you're shovel ready, and you get dollars in September of 25.
I would say it would probably take about 10 to 12 months.
Okay, thank you. Commissioner Lee.
Thank you, Chair. For Department of Agriculture, are you able to shift any of your own funds or funds from any other sources to get this work done?
If the question is, do we have excess funds somewhere else? Unfortunately, the answer is no. The way at least my programs work, they are all special or revolving funded, which means that the source of money that goes into the funds that we use for operational expenses is actually paid by users. So in the case of our Ag Park program, it's paid by the lessees who lease the state's land. In the case of the water users, it's the people who use the irrigation water. There's nowhere near enough income generated to begin a project of that size based on user fees. our what we do is we try and balance as much as possible to keep the rates as low as possible for both land leasing and water use, so that we do not run a surplus. And that's kind of what our mission is, to help farming.
Commissioner Lee. Producing local food is supposed to be a priority. Why is it so difficult for your department to convince the governor's office or whatever, or to fund this initiative?
I don't think I can answer that question. I unfortunately don't have any insight into the governor's office. Discussions with the governor and his staff have always yielded the recognition of the importance of agriculture, weighing in against, especially this year, what the other needs are of the state. I unfortunately not privy to.
Thank you, Chair.
Thank you, Commissioner. So you have no discretionary CIP funds? It's like some state departments like DOT can move $10 million one way or another. You have zero discretion?
No, we don't. We're not even a rounding error in comparison to DOT.
Okay, thanks. They have that and they still didn't build a pedestrian bridge. Okay, I think it's, commissioners, anything further? Let's take a break for lunch. It's 12:23. If I give everybody till 1 o'clock, that's 37 minutes. Is that sufficient? Or is it 47? No, it's 42 minutes. What's that? 37. Yeah. 1 o'clock. We'll resume at 1 o'clock. Thank you very much. Okay, we're back on the record. It's 1:01 p.m. And I'd like now to call on the city and county of Honolulu. Make your comments or presentation.
Hi, Pono Arias on behalf of the city. The city has no comments or questions at this time.
Thank you. Commissioners, any questions or comments on the no comments by the county? Commissioner Okuda.
Thank you very much, Mr. Chair. It's kind of like the reverse of my questions to the other applicants, or other landowners. Is there anything that landowners or applicants for permits could do to make your life down at DPP a little bit easier?
I think it would just go on a case by case basis. We do our best to work with the landowners to kind of expedite the process as best we can.
So nothing really comes to your mind as, something in flashing neon lights that you would say, hey, if people kind of focused on this, that would be, very helpful to the DPP in moving things along.
That's correct. Not at this time.
Okay, thank you very much. No further questions, Mr.
Thank
Chair.
you. Thank you very much. OPSD.
Thank you. Allison Kato, Deputy Attorney General for OPSD. Regarding Petitioner Haseko's housing project, OPSD continues to support this project, which will provide necessary infrastructure to support the Kunia Ag Park and much needed housing in in light of the housing crisis. Agricultural self-sufficiency and increased housing are important goals for the state. As discussed by others and in our testimony, an agreement was reached between DOA and Haseko to extend the deadline for the permanent infrastructure to the Kunia Ag Park, but that's on the condition that temporary utilities will be provided at an earlier time, with a bond requirement to allow the Ag Park to try and secure funding and begin constructing the Ag Park. OPSD supports this compromise and would like to see this project move forward in providing housing and infrastructure. Besides working with DOA, OPSD has also reached out to various sister agencies to request any comments or concerns relating to any relevant conditions on this matter. Specifically, OPSD contacted DOE, DOT, DOH, HIEMA, and the state sustainability coordinator. DOE, DOH, DOT, and HIEMA all responded that they have no outstanding concerns with the relevant conditions. DOT noted that they are working on finalizing an MOA with SECO regarding the timing of transportation improvements needed to accommodate the project. DOH noted that HRS Chapter 342G applies to state and county government, not to private entities such as SECO. So they have no coordination activities or plan submittals required from their perspective. Though coordination with the city may be required for proper planning of public facilities and services. OPSD did not receive comments from the state sustainability coordinator and assumes they have no concerns. So we understand that the length of time it has taken to reach this point is frustrating, but OPSD believes that HASECO, since acquiring the property in 2020, has made substantial efforts to move this project forward, and they've gotten further than anyone else has before. And DOA and HASECO have agreed on a mutually beneficial path forward, and OPSD would like to see efforts focused on getting that infrastructure in and constructing the housing as soon as possible. Regarding Ho'ohana's obligations, OPSD finds that the update on their progress is satisfactory and notes the state's interest in achieving clean energy goals. Ho'ohana provided evidence that they are in compliance with their conditions. They constructed the non-potable water line to the Kania Ag Park as they were required to do. And they have appeared to have made substantial efforts with respect to the solar farm, and it sounds like they are nearing completion pretty soon. Sorry, I have to keep clearing my throat. I was sick a few weeks ago. OPSD looks forward to the completion of the solar farm. And this is just speculation, but as the chair said, one of the reasons why it might be difficult for the legislature to commit money is that the ag park does not currently have basic utilities necessary to operate an ag park. So we feel that evidence that there is completion of basic utilities to the ag park may help DOA in securing funding for it. That's all the comments I have. I'm available for questions. Thank you.
Thank you very much, Ms. Gotham. So Commissioner Ohigashi.
Yeah, I forgot about that, about this aspect of bonding. According to the agreement, are the temporary utilities subject to being bonded by HASECO?
DOA is more familiar with the details of that. Can I have her respond?
Yes, please.
There are pursuant to the MOU, there are two bonds that are set to be issued. One is what is designated as the interim infrastructure. That is the paper infrastructure currently going through DPP that both DOA and HASECO needed to for the infrastructure. And then the second bond is the permanent infrastructure.
Okay, so with the bonding that guarantees completion of these utilities, wouldn't that be a good justification to the legislature to say that, hey, this is a project that's bonded and ready to go, and if we can time it right, we can get.
We agree with that, and that is something that we.
Has that been explored by the Department of Agriculture?
The timing of the bonding agreement, and I guess, the internal deadlines for providing budgets to the governor didn't exactly coincide to the department's benefit. But now that we do have this, it is a significant leverage that the department has for the next fiscal year and the budget with the governor.
Thank you. Commissioners, anything further? Commissioner Okuda?
Thank you, Mr. Chair. Following up on Commissioner Ohigashi, Is it true or not true from a planning perspective, which Office of Planning and Sustainable Development, since it's planning and sustainable development, I mean, is it true or is it a fair statement to say the two things we export from Hawaii is cash that we spend to buy energy and cash that we spend to buy food? I mean, that's what we're doing, right? We're exporting our cash to get food and energy, but especially food. Fair statement?
Sounds like there are other things that considerations, but unclear, sure.
Yeah, and during COVID, a big deal was being made across the board about what was called food security, correct?
I mean, food security is a prominent issue currently.
If you had to rate this agricultural park on a scale from 0 to 10, 10 being the most important and 0 meaning the Land Use Commission, we shouldn't have taken up all this time to talk about something that's really a 0. Where does this ag part fit on this scale from 0 to 10 in the eyes of the Office of Planning and Sustainable Development?
In comparison to what? Everything or?
Yeah, in comparison to everything, because if in comparison to everything that we're looking at, this is a 0, then, I'll make sure tomorrow I don't pay too much attention to the petition
It's
that,
definitely not a 0.
well, what number would you assign to it?
I mean, I think it's difficult to assign a number. OPSD tries to consider a balanced view of competing interests. Sorry, could my client respond?
Yes, please.
Did you get sworn in? Can you swear her in?
Katya, I need to swear you. Please state your name, affiliation, and also.
Hello, Katia Balaciano, Land Use Administrator for OPSD.
Do you swear your testimony today be the truth?
I do.
Please proceed.
I think food security is very important from the state's perspective. However, I respectfully say that the matter before you has to do with this particular petition and a condition associated with this particular condition. So we're not here to suggest that this ag park is more or less important than what's happening in Maui right now. I don't think that we want to weigh in on this ag park in comparison to all of the other competing needs that exist, but rather we want to speak to the condition associated with this petition in particular.
So the estimate to get this ag park going, as far as what the state needs, did I hear $20 million or $40 million?
I think DOA is 20 million.
Okay, but let's say it's 40 million. What percentage of the state budget does $40 million reflect or represent?
Again, I'm not sure that I'm here to answer that question, put that into that kind of context. We're here to answer questions about the particular petition. And the petition calls for the condition of the ag park and the infrastructure that's necessary. So from that perspective, it is important.
Well, I'm trying not to do what I've been accused of doing a lot, being too theoretical and not practical. And I think the practical thing is we all would like to see this ag park in operation, and especially if it's going to take longer than shorter to get it in operation. I would hate to see all these other entities spend a lot more money to get stuff going quickly just so that they have to wait in the end. My question is this: is it a waste of the Office of State Planning's time for somebody to go along with the Department of Agriculture representatives and try to lobby to get the money from whatever decision makers have their fingers or the ability to get this money, whether it's legislators, governor's office, Santa Claus, the Easter Bunny? I mean, is it possible to get out of our silos and work together for a common goal, or is that beyond what the state does nowadays?
The DOA and OPSD work together on many variety of issues, shared interests, and will continue to do so.
So then tell me, please, what is OPSD doing to work with the Department of Agriculture to get the DOA the money that it needs to get this agricultural park going? What specifically is being done?
We will occasionally support the DOA with legislation, but right now we're here to ask that the LUC accept the status report provided by HSECO and allow this project to go forward, and tomorrow to extend the condition and accept the memorandum of agreement that DOA and HSECO have signed.
Well, let me just ask this one last question, just to be more precise. What has the Office of State Planning done in the last 12 months to assist the Department of Agriculture to get the money it needs to get this agricultural park going? Last 12 months, just name one thing.
Yeah, we're working on infrastructure financing. We have multiple bills in front of the legislature to assist with infrastructure funding and financing. We're working on a soils report and study to better understand how soils play a regulatory role in decision-making. We've met with DOA on a number of occasions associated with this project. We contact them regularly when we're reviewing special permits that go before the counties.
Has the Office of State Planning asked anyone in the governor's office to support funding of this agricultural park?
No,
Has the
that's not something that we do. We don't lobby on behalf of our sister agencies for the funding that they request themselves.
I understand many things we don't do. Sometimes we might have to do things to move the state forward. My last question, I promise you, last question. Has the Office of State Planning spoken with any legislator about getting funds for the Department of Agriculture for this agricultural park?
Not that I'm aware of.
Okay, thank you, Mr. Chair. No further questions.
Commissioner Ohigashi.
I have one. I'm just a little concerned. The other day, I was watching television and Governor Green came out and projected $900 million surplus for this next fiscal year. Or could be this fiscal year, but next fiscal year, a $900 million surplus. So I did a calculation and it based it on $10 million that the Department of Agriculture, that's 0.01%. And my concern is that I don't, as a resident of Maui, I don't believe that state funds should be in a competition mode. And it should be ranked upon what is necessary and what is available. And if you're going to project a $900 million project and not include a $10 million surplus and not include a $10 million request to increase food security when you have improvements bonded, that is a concern to me. So I'm just going to be a regular citizen next year, and I hope that perspectives can be looked at on a question of need and what we have to do to protect all aspects of our economy. And that's just a comment. You don't have to answer that.
Thank you. Commissioners? Well, nothing there. Just one question I have. Did OPSD play any role, even a monitoring role, in the negotiation of the MOU?
Did you say monetary role?
Monitoring.
Oh,
Were you aware it was going on? Did you
yes,
participate in
I
any of the
mean, we were
discussion?
very aware. My office is right by Kelsey's. We talk all the time about it. We've discussed the history. We did that joint letter, which we worked on together. And it took a long time to understand the history of this complex matter, including the owners, et cetera, and how things have changed over time and the conditions. And we did have a meeting with Haseko and DOA to discuss all of this, and which is where the idea for temporary infrastructure sooner came up. And then they had to go and do calculations or whatever to determine exactly what they would find acceptable, what level of temporary utilities. And that is more of a technical negotiation. So the actual negotiation of the MOU, Kelsey and Curtis and their clients handled that.
Thank you. I mean, I for one think the MOU is an important step forward, and I commend you for all of you that were involved in that at the state level as well as Haseko. So we'll obviously dig deeper into that again tomorrow. But thank you for that. I have nothing further. Anybody else? Thank you very much. Petitioners, you have an opportunity based on what we've heard from the others to offer any rebuttal comments that you may have. So start with Mr. Tabata.
Thank you, Chair. I don't have anything. We're done. Thank you.
Ms. Kim, anything further you want to put on the record?
Lim. Miss
Wow.
Lim, excuse me.
Was that no?
Thank you for the opportunity. Just one comment. Counsel for OPSD mentioned that it appears that we're approaching completion. And we are. As I said, I believe we're more than substantially complete. But as you know, commercial operations isn't until the end of the year. And I'm going to use that comment as a launching pad to respond to something that was actually in the staff report, the LUC staff report, suggesting that maybe regular monitoring reports from Ho'ohana could be appropriate. And I'd like to pose this as an idea, because once this project is built, it's just smooth sailing for decades. It's either smooth sailing for 20 decades, or excuse me, for 2 decades or for 4 decades. So rather than annual reports that were never required before, we would be amenable, if the commission thought that this was of value to them, to provide you written notice once commercial operation starts. And then also written notice, as we're approaching the end of the PPA term. Again, so that the commission is always aware of, what's happening and when it's happening. And obviously, if anything material were to happen between commercial operation and the end of that PPA term, we would keep the commission informed as well. That's all I have to say, Chair.
Okay, thank you. Mr. Lee.
Chair, Commissioners, Terry Lee, we don't have anything to rebut based on the other presentations. However, I did consult with my client regarding the timing for submitting the revised master plan, and if the commission would grant us 60 days, we feel we can comfortably submit it within that time frame.
We will welcome it within 60 days if you can meet that deadline.
Thank you.
Okay, where are we going? Mr. Lau.
Thank you, Mr. Chair. We have no comments on or questions.
Okay, thank you. Commissioners, do you have any final questions or comments to the parties before we go back to public testimony? Commissioner Carr-Smith.
Just had a quick question for OPSD. I didn't hear you weigh in on the industrial parcel.
RK2's property?
Yes.
On what issue in particular?
You were going down the line and I didn't hear that addressed. So I was just curious, you just don't have any comments on what they're doing at this point?
Not at this time, because it's we have not seen their status report. It hasn't been posted yet, so we're not clear what exactly is happening.
Understood.
So we would like to see that before we'd have any comments.
Yeah, understood. Thank you.
In fact, why don't you hold them until you get this master plan in 60 days, and then you can comment on both. That'd be great. Anything further, Commissioner? No? Okay, public testimony. Ms. Kwan, are any members of the public wish to testify again or new?
No, Mr. Chair.
Thank you. Let me, I'll ask the audience, does any member of the audience want to testify publicly that did not have an opportunity to sign up? Just raise your hand. Okay, seeing none. Okay, commissioners, this is a status report. We're not required to take any action at this time, and if no action is taken, the requirement of continued annual status reports will remain. We also have received a commitment to receive an update on the master plan from the party, Mr. Lee. However, if the commission feels that its concerns have not been addressed based on the comments and responses provided by the petitioners, the chair will entertain a motion that the petitioner status report has not sufficiently addressed the commission's concerns and that further meetings or status updates are necessary to provide the opportunity to do so at future dates to be determined by LUC staff. Or that there is reason to believe that the petitioner will not adhere to the conditions set forth in the DNO and the request that the staff move forward with a formal order to show cause proceedings. I ask you for your comments and discussion and potentially any motions you want to make. Commissioner Lee.
This has been a long project, but I'm satisfied that the parties involved have been born again, and especially Haseko, I agree with their position that they're here not as a bank, not to bank entitlements. They're here to build homes, and I find that has a lot of weight. I think a lot of the relationships were clarified today, and people will be following up. Also agree with Ohana not having to do annual or 6-month reports once the project is in operation. And so for me, I don't have any problem with moving forward and following, as long as everyone is following up with what their commitments are. Thank you.
Good. Anybody else? Commissioner Carr-Smith?
Yeah, I think the petitioner has demonstrated substantial efforts made pretty much across the board. Certainly Haseko and the solar farm. Yeah, I'm comfortable with what I've heard today. Thank you.
Thank you. Anybody else? Mr. Otta?
Yeah, I just wanted to say that, my experience with Haseko has been very good over the years. And I think that you can trust as a developer to do the things that to meet the requirements. So I'm okay with that.
Thank you. See, Commissioner Ohigashi.
I have a couple of comments, and I believe that everybody's satisfied who are here, who's satisfied the status report requirement. They met the requirement that we put on for status reports is essentially to inform us where you're going, what's been happening, and what's the path forward. Our K2 partners, although late, it appears that they're coming towards and putting up deadlines for themselves to meet the requirements. So Ohana Solar did essentially prove that they've substantially completed the project. And although I don't know how it will work in the future as to whether or not you can separate them out, because as Commissioner Okuda has pointed out many times, is that this is one DBA and the condition seems to apply to all parties, and we're not sure whether they're separate out. But if it's the will of this body, I would suggest that once they come online, They'll file an annual report for 2025, and then the board can decide whether or not they can separate them out and give them a separate condition specifically for that. Or you can decide now that we can put in a condition for that. As far for Robinson Cuneo land, I hope in the future that you'll be able to tell us generally what your future plans are. I won't be here, but I hope that happens in the future. And the last thing is that we have to find out who is RK. And that's incumbent upon the staff to find out who that is. And my final comment is this: is that you know, we gave the state a hard time, the DOA and the OPSD, but the reason why we do it is because we give a hard time to the developers. We tell them, hey, you gotta pay, you gotta do this. They come up with bonds to guarantee the improvements. And I think that everything is there for us to perform on our side. And this is a state body, so state board. So I think we have a state board. And that's all I can tell you is hey, sauce for the goose. I mean, okay, that's all.
Commissioner Okuda.
Yeah, Chair, I'd like to just disagree a little bit with my dear friend or colleague, Mr. Oigashi. Okay, yeah, don't worry. It's not that I view we give people a hard time, even though sometimes it might be interpreted that way. In my view, it's the standard laid out by the rule of law, and the standard applies across the board. And I don't believe it's appropriate that we have one standard, holding certain people or institutions or entities stricter than other entities or institutions. The rules should apply equally across the board. And I think why people don't like us in government is because, many times we in government, we're not willing to live up to our own rules. And people think that we in government will make excuses when it's convenient for us. And in some cases, we've seen government officials end up in front of this commission where they admit that they've made misstatements to other government agencies. And somehow there's a belief that we in government find that okay. So all I'm suggesting is if we expect, certain entities or persons to act a certain way or behave a certain way consistent with the rules, the rule of law, the statutes, and the administrative rules, we do the same thing. I do agree with Commissioner Ohigashi that if the state of Hawaii is publicly bragging about the fact there's $900 million surplus or a significant amount of surplus, then, it's rather inconsistent not to be able to spend the money to get this 30-year-old agricultural park going forward, especially when now we see a developer with their development team actually moving rather quickly forward and effectively regarding it. So all I'm asking is that across the board, we all follow the same set of rules. But I do agree with my other commissioners that based on the evidence presented and evaluating the demeanor of the witnesses, I do not believe that any further action needs to be taken besides what's already on the table, which is the regular required status reports. Thank you.
Thank you. Commissioners, anything further? Okay, I'll offer my commentary. I agree with my fellow commissioners that, and I think I speak for the consensus that your status report today showed evidence of great progress finally in this effort. We commend you for that. we are very happy with the development of the solar farm. Those things are not easy or inexpensive, and especially in this regulatory environment and COVID, et cetera. So congratulations on the progress to date. Hopefully your COD will come through, your BESS will go vertical, and everything will work out for you. I do think personally that once you do go commercial, that we can simplify your reporting requirements, but we would want to know, obviously, if anything unexpected or catastrophic might happen during the course of the term. And of course, if you have any success in renewing or extending your PPA or getting a new PPA, we'd want to hear about that and deal with that condition that does exist. We're very pleased that Haseko has taken over the development of the housing element and is following through. And you guys have a proven track record for this type of development in Hawaii and on Oʻahu. And I appreciate your comments off the record on the hypotheticals about all that upfront work that you have to do before you can go vertical. It's just an incredible challenge. But keep it going and get that agreement with Mr. Lee done on the subcontract, on the subdividing. Get that. I'm really pleased with the MOU that you got put in place with DOA, and I have every confidence that you're going to keep going forward. I look forward to your additional reports that you'll be giving us on a regular basis. I want to offer a few comments to DOA because you heard some frustration today. But I could tell you that if I was in the legislature or the governor's office over the last 30 years, I wouldn't have given you any money either. Because these guys weren't doing their you couldn't, why spend money when you didn't have any water, et cetera, right? But now you got it. So I'd like you to interpret a lot of feedback you got for today. How can I turn this into leverage that I can get the money I need to do my part of the program? But I totally understand why you don't have any money yet. But if you come here a year from now and you don't have any money, then it's just not understandable whatsoever. And I agree that, I heard Governor Green last night talk about his $900 million surplus. And I can't understand why 1% of that would go to Department of Agriculture. 0.0. No, I think it's 0.1. Is it 0.1? 10 million out of, I don't know. You do the math. It's a small percentage. So hopefully you can get it. But unless I hear a motion to the contrary by my fellow commissioners, we're going to accept the status report as being adequate and not request any further action. So commissioners, any of you want to make a motion contrary to that? Hearing none, then that's the end of the deal. So you guys we appreciate you coming forward, taking the time to bring us up to date. And we wish you well as you go forward. We look forward to it. Thank you very much. Yeah. Okay, we're going to take a short recess. It's 1:37. We'll be back at 1:45.
Chair, before you take the recess, can I just say something very quickly, just to give, if it's appropriate to give Mr. Tabata and Mr. Matsubar heads up. At tomorrow's hearing, if you can be ready to comment or discuss two issues, and so it's not an ambush, I'll tell you what I was going to ask about. Number one, whether or not under the Enos versus the Enos Mauna Kea case, whether or not what you're asking the commission to do is an act or action which requires a kapa'akai analysis, and whether in fact the kapa'akai analysis that has already been done is limited only to the parcel that was the subject of that analysis. And number two, whether or not the Unite Here Local 5 versus City and County case, better known as the Ku'ilima case, requires an updated environmental assessment or EIS. Thank you, Mr. Chair.
Thank you. We're adjourned temporarily. We're recessed, not adjourned. Our fifth order of business, okay, back on the record, it's 1:53. Our fifth order of business is the discussion on election of commission officers for fiscal year 2025 and action if necessary. Ms. Kwan, has there been any written testimony submitted on this matter?
No, Mr. Chair.
There's no, is there anybody here that wants to testify?
No, Mr. Chair.
Okay. So during this meeting, the chair will entertain discussions and or motions regarding the election of officers. This would be for officers that would start on July 1, 2025. And our current slate of officers, including myself, is termed out on June 30th, at the end of June 30, 2024. So this would be beginning in July 1, 2024. That's
Mr.
right.
Chair,
Commissioner Ohigashi.
I'd like to nominate Dan Giovanni to remain as chair and nominate Mike Yamane to be first vice chair and nominate Kuiki Kamakea Ohelo to be second vice chair for the next term.
Is that in the form of a motion?
Yes.
Do I have a second to that motion? Okay, so I have a motion of nomination from Commissioner Ohigashi for Commissioner Giovanni, that's me, to be chair in the next session, next year, that'd be next fiscal year, starting July 1. I believe you said Commissioner Yamane to be first vice chair. Where are you going? Oh, you're retiring. That's right. Yeah, you're termed out. And Commissioner Koike Kamakela Ohelo to be second vice chair. Is that correct?
That's correct. In a happy way, I'm leaving.
In a happy way. And
you want me to comment on?
I will. I just want to put in the record that we got a second on that motion from Commissioner Melka Haley. So yeah, I would like you to and invite comments from all commissioners.
One of the things I noticed is that Chairman has been open to a lot of input from various different people, and he's conducted the meetings correctly. Most people think that the job of the chair is to make policy. I think of it more in terms of herding us cats around to try and make sure that everybody has a chance to be heard and everybody has a chance. Everybody in the audience has a chance to be heard. I think Dan has done that. Dan G has done that well. I chose Mike Yamane because I think he has the second most time in this body, and there is need for people with time and experience to take who's been involved in the meetings to take the position of chair, because that's what you really are. You're first vice chair. You just take the position of chair. You're not into policy or anything else. Well, speaking from experience, I wasn't. and Kuiki Kamake Ohelo is probably the second most longest serving commissioner. So I think that, that I think justifies my experience. And Kuiki is, if he were to take and sit and run the meeting, I think he has the compassion and the patience to handle that matter. I'm making this motion because I think that it's necessary to leave something and that everybody can build on in the future.
Thank you, Commissioner. Thank you for your kind words. I'll save my comments for the end, but Commissioner Kahele, do you want to speak to your second?
Yes, Chair, I just wanted to speak, basically, I sit on quite a bit of funds, trust funds. I've sat on several committees. HHFTC and, you know, a number of other committees. And I find the chair, Dan, you know, you've been very professional in conducting yourself. You've been very stern when people were rude in several of our hearings. And, you know, I believe, you know, you're the most qualified person here to continue to be the chair. You know, Mike is, you know, I kind of like Mike. He's quiet, you know, like, you know, Governor Ariyoshi, he's quiet and effective. Yeah, but he's effective. And, of course, Brother O'Hello, you know, he's very knowledgeable about all of the Hawaiian affairs, all of the Hawaiian issues out there. So that's basically my reason for supporting these three candidates to be the chair, first vice chair and second vice chair. Thank you.
Thank you, Commissioner. Thank you again for your kind words. Anybody else? Commissioner Lee.
Yeah, I'm gonna go first.
Yeah, you go first.
You can have the last word.
No,
Yeah, Commissioner Lee, I have no problems with anyone here, and this by no means is am I speaking out of disrespect, and I'm sorry if my comments you know, might be uncomfortable for some, but and I know that the vote will go through, but my observation is that on the agenda it says election if necessary, and I don't think it's necessarily necessary. In the past, the election of officers has been skipped for years, and the fiscal year does start July 1st. There will be 3 new people, and it would be, to me, a gesture of inclusiveness to wait till then. But I know that those are only my observations, and I respect the views of everyone else. Thank you, Chair.
Thank you. Thank you, Commissioner. Others? You deferring? Oh, Commissioner Carr-Smith.
Thank you. I do agree with what Brian said, that it makes more sense to me to have the new commissioners come in and vote on new leadership or same leadership. It just makes more sense to me than having outgoing commissioners vote. But having said that, I appreciate your leadership, and I've enjoyed getting to know you and working with you. I'm speaking to you, Chair. Obviously, I will support you.
Thank you very much. Commissioner Otten.
Yeah, I'm going to be going off in July, but I just wanted to say it's been a good experience, and you know, being a part of this commission, and so I just want to thank everybody. And I think the new new officer will be really good to follow through, and you know, and Dan, I just think it'd be a good leader to keep everybody together again.
Thank you, Commissioner. Commissioner Yamani.
Thank you, Chair.
I'd say Commissioner Ayoshi.
First of all, thank you for the nomination. Do I have a choice to accept that nomination?
Just like me, you don't.
First, no, I fully support our current chair to be our chair in the future. He's demonstrated a fully collaborative commission and inclusive of all the petitioners in front of us. And also I support Commissioner O'Hello as second vice chair. Just wanted to speak on the inclusiveness brought up by other commissioners. I think every year is possibly we could go through this. So next year, when we do have a new slate of commissioners, there's always a possibility that happens. So it's not like that's not going to happen. So, but again, I'm supportive of all the nominations. Thank you, Commissioner Hoigashi, for this nomination.
Thank you, Commissioner. Commissioner Okuda.
Yeah, thank you, Chair. Since tomorrow, I guess, is my last day, you know, or last meeting, but it's basically the last day. There's no other meetings. I am going to support the motion, and this is the reason why. I think number one, the chair just like a judge in a courtroom, one of the most important things is demeanor. Anyone can have intelligence, but not everyone can have demeanor. And the importance about demeanor is that when the public comes in front of the commission or watches the commission on YouTube or anything like that, the public really has to leave with a feeling that they might not have gotten everything that they wanted, but they have to leave with a feeling that they were being treated fairly. I think that's the reason why people don't trust us and don't like us in government, is the feeling of unfairness. I can think of many hearings where you've demonstrated communicating the fairness of the process, but let me just point out one which I think highlights it. It was the Mauna Kea case. If there was ever a case where people should have left pissed off, angry, ready to throw stones or do other things, it was the Kanahele petition. And, at that, it was, I can't even say it was contentious, because the way you ran the meeting, everyone, whether it was the University of Hawaii or the anti-TM, oh yeah, I'm sorry. Yeah, Jonathan was running the meeting, but I talk about that because of the fact that, you and Jonathan were the dissenting voices there. And the dissent that you explained at that meeting, communicated fairness to everyone in the room. And in fact, if you look at the Supreme Court decision, which was a 3-2 decision, upholding the Land Use Commission, but the two dissenters pointed out the dissent that you and Jonathan raised at that hearing. And we all know that actually it was the anti-TMT people who came and shook our hands at the end and asked and thanked us for actually listening to them. I think you've shown the same type of demeanor in the way you've handled all these hearings, even in the hearings where I disagreed with what the ultimate vote was that you voted for. So, you being chair communicates fairness, and I think that's really, really important, for credibility, not only of the commission, but for the government in general. So that's the reason why I'm thankful that you're willing to continue to serve. And, that's the reason why I'm supporting the motion.
Thank you, Commissioner. I think that's everybody that's here today. I am humbled by the support you have all expressed for this group of us to continue in a leadership role on this commission. This commission, as it's been pointed out, is going to undergo a significant transformation. I mean, here I sit, the senior person on this commission, and 3 years ago I could hardly spell LUC. I was so new to the game. So it's going to be a very a board that is not a very long tenured board among its 9 commissioners, with 5 basically commissioners out of the 9 having served no time or less than a year. So from that point of view, I really believe that for the reasons of continuity and consistency, it is important to lean on those of us that have been around a little while, not a long time, but a little while. And so I think I support the move, and I welcome Commissioner Yamane and Commissioner O'Ahu in leadership roles as well. So I will vote in favor of the mission, and I appreciate the nomination. So thank you very much. Any further comment before we take a roll? So Mr. Undanker, will you take a roll call vote, please?
Thank you, Mr. Chair. The motion is to elect Dan Giovanni, Chair, Mike Yamane, Vice Chair, first Vice Chair, and Koike Kamakea Oʻahu for second Vice Chair for a term starting on July 1. Commissioner Ohigashi. Aye. Commissioner Kahele.
Aye.
Commissioner Yamane.
Aye.
Commissioner Carsmith,
Aye.
Commissioner Atta,
Aye.
Commissioner Ohigashi. Oh, that's right. I got you twice. Yeah, I got you
You get only
twice.
one vote.
You only get one vote. No, you get two.
I also vote aye.
Okay. Commissioner Hokuda,
Aye.
Commissioner Lee.
He said aye.
Okay. And Commissioner Kamakeo, hello, is absent. Did I miss anybody? Oh, Commissioner, yeah, well, besides you, Commissioner Giovanni.
Aye.
Thank you, Mr. Chair. The motion carries unanimously.
Very good. Thank you very much. And staff put that into effect, I guess, in terms of our records, and then on we go. So I appreciate the continuity and the support. And I look to work with each of you and give each of you full opportunity for express your voice and your concerns and your positions as we go forward. If ever you feel that is not the case, I expect to hear from you personally. Let me just say that. Okay, our sixth order of business is the potential for an executive session pursuant to HRS section 95-5A2 to consider personnel matters. Thank you, Mr. Morris. Section 92-5, paren A, paren 2. To consider personnel matters where considerations of matters affecting privacy will be involved. Before we get into testimony and commentary and even a motion to go in executive session, I'd like to call upon our Mr. Morris to express a position, if you would, an opinion of the procedure that we are looking possibly to embark into executive session, where basically in private, the full commission will have discussions on this personnel matter. Now, let me also further clarify that this is not a order of business to actually perform any evaluation at this time. It's really to potentially discuss the process by which we may do an evaluation. So, Mr. Morris.
Thank you. First, I want to thank Commissioner Lee for directing my attention to a relatively recent Hawaii Supreme Court case from 2019 involved the Civil Beat versus the City and County of Honolulu, the Police Chief Commission case, where the Supreme Court addressed the issue of whether an executive session to address personnel issues was something that was automatic or required, and the extent to which there should be some other approach to that. And, you know, the case is instructive. And I think what I gleaned from the case was that it's not an automatic executive session matter. There first has to be some statutory criteria that are met, and it's a discretionary call. So in that sense, Chair's suggestion that there be a motion to go into executive session would be appropriate, and it would be within the discretion of the commission as to whether that takes place based on the extent to which personal or private information might come out or would come out in that discussion. And, you know, the case does give some guidance in terms of when that type of privacy interest would be affected. It's a case by case analysis. There's no bright line rules. The case mentions that highly personal and intimate information may include medical, financial, educational, or employment records. I think that the court recognized that the bell can't be unrung, and so it's appropriate to go into executive session at the very beginning if there's an anticipation that those matters will come up, so as not to again have something in the public record that would be an intrusion on privacy. So, you know, there's no clear answer as to when that is or isn't involved. I will note that in that particular case, there was a discussion about high-ranking public officials having some diminished level of privacy in certain aspects of their affairs because of the strong public interest. And I don't necessarily think, with due respect to our executive officer, that that is not a position, a high top rank position. It's not the example used in the case of the president of the University of Hawaii, or in that particular instance, the police chief of the city and county of Honolulu. So I don't think that there is the same diminished level of privacy interest, at least in the financial records. I do know that to the extent that a salary number will be determined, those salary numbers are a matter of public record. But matters contained in the personnel file of a state employee are subject to privacy. And to the extent there's an evaluation of personnel performance, or to the extent that medical issues or other ancillary financial issues might be part of that discussion, that certainly would constitute a privacy interest that would, I think, support the discretion of this commission to handle those matters in executive session. So I think with that background, I wanted to make sure, and again, thank Commissioner Lee for pointing that out to me, and make sure that when this board considers a motion to go into executive session, they understand it's not an automatic process, and their decision in exercising that discretion depends on the extent to which personal private information would come up in that discussion.
Can I ask a question?
Commissioner Okuda.
Mr. Chair, if this motion is going to involve our executive officer, I wish to be, or asked to be, excused from this discussion. And if necessary, Mr. Orendenker can explain the reasons why.
May I comment?
Yes.
So a year ago, you took that same position and it was respected.
Yes.
And you may choose to, if the motion is made to go in executive session, you could abstain from voting on that. It is your pleasure. And then if we go in executive session, you can recuse yourself if you so wish.
Yeah, I would rather just recuse myself on all of that.
Okay.
By the way, I wasn't representing the executive officer in a criminal case or anything like that. It's a routine thing, but I just believe it's more appropriate in this case that, just so that it's absolutely clear, I not be involved in anything dealing with Mr. Orendenker.
The chair accepts that
Thank you.
and respects it. Thank you. Commissioner Oigashi.
My question to Mr. Morris is whether or not, if we do go into executive session, is it proper, is it okay to have the Deputy Attorney General there, yourself there, in order to guide us, to tell us whether or not we are, whether our discussions actually should be made in public or not, or and on the safe side, and if so, we would keep good notes for the purposes of stating what was said or what was done in executive session.
Yes, I'm certainly happy to attend, and I think it would be appropriate to do so. Some of the parameters of executive session is you're really not supposed to stray from the reason that you went into executive session. Minutes of the executive session are important to be maintained. And at the conclusion of the executive session, there should be a brief summary in open session summarizing the action taken, or in summarizing what was done during the executive session in a way that doesn't sort of defeat the purpose of it in the initial instance. And so I'm happy to participate, and I believe that's appropriate.
And it's customary for the second vice chair to do. Oh, the mic is not on. I'm sorry.
Did you want to go on? No. Okay. I just want to confirm, have we had any public testimony on this? Okay, no. So, any other comment before the chair entertains a motion? Commissioner Lee, since your name was mentioned a few times, please.
Thank you. Thank you. I think it's appropriate for Deputy AG Morris to be with us in executive session. And that's usually the practice. But we would, I guess, have to declare that we want him in there just to make it official. Lee, you want to say something? Sidebar?
I just wanted to see if you would volunteer to do the minutes.
No. And I appreciate Mr. Morris's attention to my question regarding the case that I cited, and him looking into that. I do have a comment though. I think it's a judgment matter, what is an important board or what is an important position. You know, that's a judgment call. I will point out though that our board is important enough that we all have to file public financial disclosures. And it's not a blanket thing, as. Yes, Mr. Ogashi? I'm not sure what that was about, but, yeah. And so I appreciate that, it was clarified, I think, that this, executive session is for just discussion of the process.
So I will give guidance on that.
Okay.
Yes.
Because to me, this wording is not clear enough for the layman to understand what this was about, if it was to be the actual evaluation. You know, it should be worded enough so that a member of the public could read this and say, oh, I want to testify on the evaluation of Dan Orodenker. But if I just read this, I don't get that clear message. And actually, I think Dan would fare pretty well if there was public input. And so it would help give a message to people from the public that we're reviewing things in a transparent way and that he has the support of the commission. And so I would urge that in the future, when there is a actual evaluation, that it be more clearly stated in the agenda, and that they would give the public an opportunity to weigh in if they so desired. I know that last year, no one even knew that there was an evaluation going on of the executive director, nor that any pay adjustment was done or anything like that. So that's all I had to say. Thank you.
Thank you. Any further comment? So, yeah, the chair's expectation is that we will follow a process similar to, or something that might be amended from what we've done in previous times. But in my 3 previous years on this commission, it was all done pretty similarly. And that was that a commissioner would take the lead in distributing evaluation forms. It's a pretty standard form. And each commissioner would be given the opportunity to do a independent, quantitative, personal evaluation on several different categories of the job. And then to offer commentary, if they so choose, voluntary commentary on any aspects in those same categories. And then the evaluation forms would be compiled and totaled and averaged, the quantitative part. And comments would be summarized. Then that information would be brought back to a working meeting of the commission to do the actual evaluation and make and form some position on the performance and any recommendation it wants to make about salary. That's the process that has occurred before. So it's a process such as that I think makes sense for us to discuss in executive session today, but not to do the evaluation today. That we do differently. Okay. With that clarification, I would entertain a motion to go in executive session.
So move in accordance with the request done by the chair.
Do I have a second?
Second.
Commissioner Yamane seconds the motion made by Commissioner Ogashi. All those in favor signify by saying aye and raising your hands.
Aye. Aye.
Any opposed? The commission will now enter executive session. Back on the record, it's 2:47 p.m. We're just exiting from executive session. So just for the record, I'd like to speak to what we have decided, what we were doing. So the executive session, we focused on our going forward with the performance evaluation of our executive officer. And we dealt with both the privacy aspects that would be just evaluated and discussed in the context of that performance evaluation and how they should be managed, as well as the process by which we choose to go forward. So what we've are requesting and have agreed to as a commission is the following. Similar to how we've done it in prior years, we have a form, a performance evaluation form that will be specific to the performance of our executive officer during the current fiscal year. And we ask each commissioner to complete that form. Commissioner Okuda is recused himself, so he will not be included. To complete that form, that form will be issued by early next week by Commissioner Ohigashi, who will facilitate the completion of those forms and the compilation of the results from those forms. The form will be sent to each commissioner independently and then returned to Commissioner Ohigashi independently. In addition, a copy of that same form will be sent to Executive Officer Orendenker, and he will be asked to do a self-evaluation on that form and send it to Commissioner Ohigashi. Okay. In parallel with that, we ask that the executive officer or his staff make a copy of his current employment contract available for each commissioner. So you could send a copy of that. Let me ask the executive officer to do that again next week. And then we have a desire to see the budget, the current year budget and the proposed fiscal year 25 overall budget for the LUC. Is that correct? Yeah. So if you have that in any form, we'd like to see that as well. Then we'd ask that all those forms be completed and returned to Commissioner Ohigashi by the end of April, end of April. And we will shoot to have a executive session at our meeting on, I believe it's May 8th. And we will have a discussion on the results from the independent evaluations, and we'll move forward from there.
Question, Mr. Chair, the budget, do you want the entire budget or just the personnel budget?
I think entire budget, if it's available. Yeah. Yeah, I think the entire budget. You should have that so it's not making new work, is that right?
No, yeah, no, it's just two different pieces of paper.
Yeah, just, that would be great. But the entire budget has the personnel part in it, right?
Yes.
Yeah, okay. Did I miss anything for the commissioners? That's it? Okay, do I have a motion to adjourn? All in favor? We're adjourned.